May I please?
Yes, Mr. Ahmad.
My lord, I have prayer in item number 10, my lord.
Hmm.
My lord, in this case, my lord, I have come with a different file, my lord, having same name, my lord. I'm very sorry, my lord. Lord, you will kindly post this case another day.
Let the matter reads first. We'll do it.
My lord.
May please, Lordship. I beg to item number 2, Lordship. I am on behalf of RS Swan, Lordship. He is out of station, Lordship. Lordship may be taken, matter may be taken
Let the
next.
matter reach.
Obliged.
It's an admission.
May I please, Lordship? Lordship, I beg to mention item number 7. In this case, my senior was being afforded as MI cash. Lordship, today she is not available.
Who's your senior?
Vigos.
Thank you.
May it please the Lordship. Lordship, I beg to mention item number 2, Lordship. Learned petitioner advocate, Lordship, asked me to mention the matter, Lordship. He is in personal difficulty, Lordship.
Don't worry, it's an admission matter. We'll just pass the necessary order.
Lordship. Much appreciated.
Or wait till the status. No, no, again, we don't.
Item number 1, 2, 3, 2.
No, my petition. 2. More. 2 মানে কি? 2.
Okay, on Thursday we'll have it.
Lordship, he is in, outside Assam, Lordship. RS Sohan, Lordship. He asked me to mention. I am not in the case, Lordship.
On 13th.
Much okay.
In the prayer of Mr. R.S. Sohan also put it. This one, 13th. Yes, Mr. does tell us now what to do.
Your Lordship, on the other day told us to go through 223 online STC page 996.
No, here, that is the recent judgment on which the Honorable Apex Court have
Yes.
briefly have dealt, not briefly, has elaborately dealt with the provision of certiorari, how
Yeah.
the High Court should consider it. Now, here in this particular matter, we have pointed out how the petitioner remain absent, and probably you have also gone through the records. So tell us what to do, in what circumstances are now, in which, in exercising the power of certiorari, how can you?
It is good, just not.
No, Lordship is taking item number 1.
Yes.
Jyotsnarani Shaha.
Huh.
No, it is not an expert in it. He is interpreting. But probably your Lordship is,
Okay, please, clear.
I guess. That is a defined case. Not
Yes.
that is also in the today's list, that is a supplementary list. Now, my lord, on the last occasion, my lord, we have dealt with the facts of this case, my lord, and your lordship told me to go through this judgment, that is Supreme Court online, my lord, as 2023. Lord, I have gone through it, my lord. Now, my lord, what transpires to me in this judgment, the basically read jurisdiction is the jurisdiction of the king. Now, probably for that reason, we call this court as a lordship, not as a sar or honor. honor. Now, my lord, so far this jurisdiction is concerned, the court, so far the certified certiorari jurisdiction is concerned, court will call for the record of the tribunal to certify them so that they can examine it. And while examining that record, court will confine itself to the extent whether the tribunal has committed some manifest error or not. That error must be an error apparent on the face of the error of law, apparent on the face of the record. So when this error of law will come or will be considered, that has been discussed in this judgment, my lord. Lord, while dealing with this case, my lord, the apex court was of the view that so far the writ of certiorari is concerned, Lord, may I read some paragraphs? So far my judgment is concerned, I am going through 2023-11 SCR page 731.
Sharma.
Two 2023-11 SCR. Page 731.
Yeah, HCC on. Mr. Payam, it was 995.
996.
996, ma'am.
SCC online 996. 2023 SCC online 996. Not
SC 996.
sorry, 2023 SC 996. Normally, I could not brought this up, but the equivalent judgment is 2023 1 STR, page 3731.
Yes, sir.
Want to go to SCR?
My move to SCC. 2023 SCC online 9 SC 996.
731 no, na?
अपना पे है मालिक
Oh, I do.
2023 SCC.
Yes.
What the page number?
996.
No, relevant page number.
Yes, you just give us the paragraph number.
Paragraph number.
SCR.
From SCR.
From SCR paragraph number, it starts paragraph number. Forty-nine. Two credential principles of law governing the exercise of extraordinary jurisdiction under Article 226 of the Constitution, more particularly when it comes to the issue of a writ of certiorari.
That's 50 in this matter. Yeah, 50.
Yeah, 50. Okay. I will just point out some paragraphs, not all. Now, paragraph number 49, it states, paragraph number 50. Probably, you are also going through SSC online? SSC online?
You go ahead,
No, no,
we'll,
go.
we'll note down the paragraphs. Okay.
Hmm.
In your case, it is 51, right? 40,
No, in my 50,
50.
SCR. I probably it is 50, 49.
Here also 50.
50, then all, no problem. Now, so gist of this paragraph is that read code is not a court of appeal. Now, first cardinal principles of law that govern the exercise of extraordinary jurisdiction under Article 226 of the Constitution, more particularly when it comes to the issue of a writ of certiorari, is that in granting such a writ, the High Court does not exercise the power of appellate tribunal. It does not review or reweigh the evidence upon which the determination of the inferior tribunal purports to be based. It demolishes the order. It demolishes the order which considered to be without jurisdiction or palpably erroneous. That is very mild. Palpably erroneous, but does not substitute its own view for those inferior tribunal. The writ of certiorari can be used if an error of law is apparent on the face of the record. Main thing is the error of law should be apparent on the face of the record. This is the cardinal point of discussion of this paragraph. Now, what is error of law? That has been discussed in the subsequent paragraphs. The writ code can be issued an error of law apparent on the face of the record. A writ of certiorari, being an high prerogative writ, should not be issued on a mere asking. So basically, Lord, if the tribunal has committed any error of law, then and only then the writ code can interfere. But all error of law should not be entertained. Only the things that the error of law which is apparent on the face of the record. There is a basic difference of error of law and error of law apparent on the face of the record. Now the real question is that what would constitute the error of law apparent on the face of the record? That has been discussed in this case. Now let's so for 51, error of law apparent on the face of the record, and you should bear it in mind. So for 51, paragraph 51 is concerned, the gist of this paragraph is that the writ code is a court of equity. Equity is the essence of the writ jurisdiction. So for paragraph 51 is concerned. Very, no?
Please.
The second cardinal point, first cardinal point is this error of law apparent on the face of the record. Now, second cardinal point, second cardinal principle of exercise of extraordinary jurisdiction under Article 226 of the Constitution is that in a given case, even if some action or order challenge in the writ petition is found to be illegal and invalid. So some order may be illegal or invalid, then also writ code will not interfere. The High Court, while exercising its extraordinary jurisdiction thereunder, can refuse to offset it with a view of doing substantial justice. So substantial justice is the essence of the writ code. Between the parties, Article 226 of the Constitution grants an extraordinary remedy, which is essentially discretionary. Although founded on the legal injury, it is perfectly open for the court, for the writ code, exercising this flexible power to pass such order as public interest dictates the equity projects. So look, first thing is that there should be an error apparent on the face of the record. Second thing is that the substantial, for the cause of substantial justice, and for that reason, equitable principles are to be applied. This is the first case in the history of the Supreme Court, my lord, where it is specifically stated, the public interest dictates the equity projects. The legal formulations cannot be enforced divorced from the realities of the fact situation of the case. While administering law, it is to be tempered with equity, and if the equitable situation demands, after setting right the legal formulations not to be taken to be the logical end, the High Court would be failing its duty if it does not notice the equitable consideration and mold the final order in exercise of its extraordinary jurisdiction. Any other approach would render the High Court a normal court of appeal, which is not. So now, so long, my lord, we have come 3 points that High Court, while exercising the jurisdiction, shall not act as a court of appeal. Secondly, Lord, the High Court, while exercising its jurisdiction, shall only entertain when there is an error apparent on the face of the record. And third thing is the error means the error of law. And fourth thing is that while exercising the jurisdiction of the writ court, my lord, the High Court should consider the substantial justice, and while dealing with the substantial justice, they must consider the equitable principles, my lord. That is paragraph 51. Now, my lord, if your lordship come, paragraph 52. Let us keep it up for first three or four lines. Or let me read it. The essential features of writ of certiorari, including the brief history, have been exhaustively explained by B.K. Mukherjee in T.C. Basappa versus Nagappa and others, reported in AIR such and such. The court held that a writ in the nature of certiorari could be issued in all appropriate cases and in appropriate manner, so long as the broad and fundamental principles were kept in mind. These principles were delineated as follows. I will read one paragraph only. In granting a writ of paragraph 7, in granting a writ of certiorari, the superior court does not exercise the power of appellate tribunal. That is repeatedly said. It does not review or weigh away the evidence upon which the determination of the inferior tribunal purports to be based. It demolishes the order which is considered to be without jurisdiction. If it is without jurisdiction or palpably erroneous, but does not substitute his own view for this own inferior tribunal. Repeatedly, they are saying that this court should not substitute its own view. It has a limited applications. If it is erroneous, apparent on the face of the record, or now therefore is beyond jurisdiction. Now, my lord, your lordship come to. All right, let me read paragraph 53. Three or four principles of laid down. Number one, certiorari will be issued for correcting the errors of jurisdiction, as when an inferior court or tribunal acts without jurisdiction or in excess of it, or faults it in exercising. Now, Lord, why I am stressing that without jurisdiction, Lord, that I will explain, Lord, later on, Lord. Certiorari will be issued when the court or tribunal acts illegally in exercise of its undoubted jurisdiction, as when it decides without giving an appointment. That is not relevant. The court issuing the writ of certiorari acts exercise supervisory and not appellate is not relevant. Only thing is only one, without jurisdiction. Now your lordship come, paragraph 14. This is same thing. It is a repetition of the it should not substitute its own finding. That is, let us keep it up. Now, your lordship come to paragraph 55. in Syed Yaqub versus such and such, reported in AIR 1964-477, P.B. Gajendra Gatkar, CJ, speaking for the Constitution bench, placed the matter beyond any position of doubt by holding that a writ of certiorari can be issued for correcting errors of jurisdiction. Repeatedly, I am emphasizing and the errors of jurisdiction. Let me tell you later on what. Errors of jurisdiction committed by the inferior courts or tribunal. The observation of this court is in paragraph 7 are what taken to note. Now, these are three or four factors has to be considered. One is error of law, which is apparent on the face of the record, gist of this paragraph. Second, it can be issued on or refusal to admit on refusal to admit admissible evidence, material evidence, or no evidence. This is the gist of this paragraph. Let me read it out. The question about the limits of the jurisdiction of high courts in issuing a writ of certiorari under Article 226 has been frequently considered by this court, and the true legal position is that behalf is no longer in doubt. A writ of certiorari can be issued for correcting the errors of jurisdiction. That is very much important here. So far, my case is concerned. Errors of jurisdiction committed by the inferior court or tribunals. These are cases where the orders are passed by the inferior tribunal without jurisdiction or with excess of it. So errors of jurisdiction, without jurisdiction, or excess of jurisdiction. Now, these three factors have to be considered. Where excess of jurisdiction conferred on it, the court or tribunal acts illegally or improperly. As for instance, it decides a question without giving any opportunity to be heard to any party affected by the order, or where procedure adopted in dealing with the dispute is opposed to the principles of natural justice. There is, however, no doubt that the jurisdiction to issue writ of certiorari is a supervisory jurisdiction. That is very much important. Supervisory jurisdiction, and the court exercising it is not entitled to act as an appellate court. Repeatedly they are saying so. The limitation necessary means that the finding of fact reached by the inferior court or tribunal as a result of appreciation of evidence cannot be reopened or questioned in a writ proceeding. So the reappreciation of evidence is not permissible. Now, an error of law, that is it is now very much important. An error of law which is apparent on the face of the record can be corrected by a writ, but not an error of fact, however grave it may appear to be. In regard to a finding of fact recorded by the tribunal, a writ of certiorari can be issued if it is shown that in recording the said finding, the tribunal had erroneously refused to, a very much important word, erroneously refused to admissible and material evidence. This is very much important. The writ can be issued if it is shown that in recording the said finding, the tribunal had erroneously refused to admit admissible finding and material evidence, or had erroneously admitted inadmissible evidence. So far, our cases that may not be applicable. Evidence which has influenced the impugned finding. Similarly, this is not very much, this is not very relevant so far our case is concerned. Similarly, if a finding of fact is based on no evidence, it is not a case of no basis, that would be regarded as an error of law. Now, which can be corrected by the writ of certiorari. In dealing with this category of cases, however, we must always bear in mind that a finding of fact recorded by the tribunal cannot be challenged in proceeding for a writ of certiorari on the ground that the relevant material evidence adduced before the tribunal was insufficient or inadequate to sustain the impugned finding. The adequacy or sufficiency of evidence laid on the point of the inference of the fact to be drawn from the said finding are within the exclusive jurisdiction of the tribunal, and the said points cannot be edited before the writ court. It is within these limits the jurisdiction conferred by the High Court under Article 226 to issue a writ of certiorari can be legitimately exercised. What I have understood from this paragraph is that though High Court cannot exercise, reappreciate the evidence, but the High Court has to see whether some inadmissible evidence were entertained, whether some relevant evidence were not considered, whether the finding of fact is not based on any evidence. There is no way. There is perversity in that. Now, next paragraph 36. In Suryadev Rai versus Ramchandra Rai and others reported in such and such, a bench of 2 judges held that the certiorari jurisdiction, though available, should not be exercised as a matter of course. The High Court would be justified in refusing the writ of certiorari if no failure of justice had been occasioned. In certiorari jurisdiction, the process for making a reference. Where the jurisdiction of a body depends upon the preliminary finding. This is very much important. Whether the tribunal acquired its jurisdiction to entertain this reference, that has to be considered. And if it depends on some preliminary finding, that has to be explained. Upon a preliminary finding of fact, in a proceeding for a writ of certiorari, the court may determine whether or not that finding of fact is correct. So, when the tribunal will entertain a case, the tribunal should examine whether he has the jurisdiction or not. And for that purpose, the tribunal shall consider some factual aspects. And the High Court, while considering this aspect, whether the tribunal considered those facts or not to entertain its jurisdiction, then the High Court in a writ jurisdiction can examine to that effect. I read again. It may also arise from the absence of some essential preliminary or jurisdictional fact, where the jurisdiction of a body, that is a foreigners tribunal, depends upon a preliminary finding. He has to make a preliminary finding of fact. In a proceeding of writ of certiorari, the court may determine whether or not that finding of fact is correct. So, for this preliminary fact is concerned, to entertain his jurisdiction, this court can examine whether that finding is correct or not. The reason is that by wrongly deciding such a fact, the court or tribunal cannot give itself jurisdiction. Now, my lord, so what I am on, my lord, the tribunal while entertaining these proceedings must examine to the effect whether it has jurisdiction or not. And for that purpose, it should be satisfied on himself that he has a jurisdiction. And for that purpose, some factual aspects are to be considered. And if that factual aspect is correct or not, that can be examined by the report while deciding the jurisdictional error or exceeding of jurisdiction or no jurisdiction, etc., etc. To that effect, the Reed Court has a very, very limited power to examine whether that aspect has been considered or not.
Yes.
Now, that's paragraph 15. That is exceeded jurisdiction at the threshold. At the very threshold, my lord, the jurisdictional point has to be examined. Now, such and such, it is a House of Lords case, reported in such and such. The House of Lords has given a very broad connotations to the concept of jurisdictional error. It has been laid down that a tribunal exceeds the jurisdiction not only at the threshold when it enters into an inquiry, but when it is not entitled to undertake. This is so far as our Supreme Court judgment is concerned. In order to fortify the judgment of the Supreme Court, they have referred to the House of Lords judgment. The House of Lords has given a very broad connotation to the concept of jurisdictional error. It has been laid down that a tribunal exceeds jurisdiction not only at the threshold when it enters into an inquiry which is not entitled to undertake, but it may enter into an inquiry within its jurisdiction in the first instance, and then do something which would deprive of its jurisdiction and render the decision a nullity. In other words, Lord Reed, wait. There may be cases where the authority, although the tribunal has jurisdiction to enter on the entire inquiry. First thing is whether the tribunal has the jurisdiction to enter in the inquiry. Even second thing is that even the tribunal has the jurisdiction to inquire in the inquiry, then what is to be done? That has been indicated. But there may be cases when although the tribunal had jurisdiction to enter on the inquiry, it has done or failed to do something in course of inquiry, which is of course such a nature that its decision is a nullity. It may have given its decision on bad faith. It may have made a decision which had no longer no power to make. It may have failed in course of inquiry to comply with the requirements of natural justice. These are the factors they have indicated. It may, perfect good faith, have misconstrued the provisions giving in the power, so that these three or four lines are very much important so far our case is concerned. That it failed to deal with the question remitted to it and decided some question which was not remitted to it. It may have refused to take into account something which is required to take into account, or it may have based on its decision some more matter which is under the provisions of setting up, and it had no right to take account or to go intend to be exhaustive. Now, Milord, what I have understood in this case, Milord, when a court will entertain his jurisdiction, he will consider whether the tribunal or the concerned authority had applied its mind to reach the relevant factors. If the factor is not relevant, and for consideration of that irrelevant factor, the tribunal came to an extraneous finding, then the writ court can interfere. Whether the factors to be considered by the tribunal is relevant or not, or if the tribunal or the court was influenced by the factor which is not at all relevant for decision, then that finding will be considered as an extraneous consideration. And in such case, the writ court can interfere. Now, second thing is that who for error of law is concerned, this is very much important. When this error of law can be concluded. Let us read it slowly. Who for the error of law are concerned, a writ of certiorari could be issued if an error of law apparent on the face of the record. To attract this writ of certiorari, a mere error of law is not sufficient. It must be apparent on the face of the record. It must be one which is manifest or patent on the face of the record. Mere formal or technical errors, even of law, are not sufficient so as to attract a writ of certiorari. As reminded by this court time and again, this concept is indefinite and cannot be indefinite and cannot be defined precisely. There is no hard and fast rule, my lord, precisely or exhaustively, and so it has to be determined judiciously. No formula can be laid down, my lord. Judiciously on the facts of each case. The concept according to this code in such and such versus such and such, area such and such, is comprised of many imponderables. It cannot be capable of precise definition. So as no objective criterion could be laid down the apparent nature of error, to a large extent being dependent upon the subjective element. A general test to apply, however, is that no error could be said to be apparent on the face of the record if it is not self-evident or manifest. If it requires an examination on argument or to establish, it has to be established by a long drawn process or reasoning. The lengthy or complicated arguments on the point, there may considerably be two opinions, then such an error would cease to be an error of law. So now, error, simple thing, error must be apparent. It should not be determined by through an intensive argument. Any person who can say, yes, there is an error, that should be considered an error apparent on the face of the record. Now, look, how this error apparent can be determined, there is no such hard and fast formula that has been laid down at paragraph 60. However, in our opinion, such a test should be applied, in our opinion, such a test should not be applied in a straitjacket formula. It depends on the facts of each case. And may fail because what might be considered by one judge as an error self-evident might not be considered by another judge. No.
Please go on.
May I go?
Go ahead.
Now, Your Lordship, paragraph 61. Okay. Now, paragraph 61, gist of this paragraph I have written in the silence. Gist of this paragraph 61 is that error of fact, even though it is apparent, cannot be interfered. At this stage, it may not be out of place to remind ourselves of the observations of this code in Sayyid Yusuf on this point, which are as follows. Where it is manifest or clear that the conclusion of law recorded by the inferior court or tribunal based on obvious misinterpretation of relevant statutory provisions. That is also considered relevant statutory provision or something in ignorance of it, or may even in disregard of it, or expressly founded on reasons which are wrong in law. The said conclusion can be corrected by a writ of certiorari. Certiorari will not lie to correct the mere errors of fact, even though such error may be apparent on the face of the record. The error may be two kinds. One may be error of the fact, and one may be the error of law. The writ court shall entertain only to the effect where there is an error of law. But some error of fact will be considered as an error of law. What are those facts? That when the court came to a conclusion without any evidence, when court considered some inadmissible evidence, when court has considered some erroneous things, which is so totally error of fact cannot be ignored, but more or less error of fact should be ignored. Errors may be apparent on the face of the record. The read jurisdiction is a supervisory jurisdiction. That is very much important. After it is the jurisdiction of the king. King should not examine all these things. King should only look at whether his subordinate authority had committed any mistake or not, which is apparent on the face of the record. If the king is of the view that yes, my subordinate authority has committed something which is apparent on the face of the record, then and only then the king will interfere. That is the concept that has grown in UK, and it has been derived in India. Even though such errors may be apparent on the face of the record, the writ jurisdiction is a supervisory, and the court exercising it is not to act on an appellate court. King will not be an appellate court. It is well settled that the writ court would not reappreciate the evidence and substitute its own conclusion of fact for that recorded by adjudicating body, be it a court or a tribunal. A finding of fact, howsoever erroneous, recorded by a court or tribunal cannot be challenged in a proceeding for a writ on the ground that the relevant and material evidence before the court or the tribunal was insufficient or inadequate to sustain the impugned findings. So basically the appreciation of the evidence. It is well settled that the adequacy or sufficiency of evidence laid on a point and inference to a fact to be drawn from the said finding are within the exclusive jurisdiction of the tribunal, and these points cannot be agitated before the writ court. Now, my lord, for the timing, we can skip off paragraph number 62, though it is important, but so far my case is concerned, it is not relevant. Let us come to paragraph number 63. All right, let me read paragraph 62 also. The finding of the facts recorded by the fact-finding authority duly constituted for the purpose and which is ordinarily should be considered to have become final, cannot be disturbed or for the mere reason of having been based on materials on evidence not sufficient to or creditable for the opinion of the read court to warrant this finding at the end of the at any rate. It's the same thing. The court will not act as an appellate court as long as they are based upon such material which are relevant for the purpose, even on the ground that there is yet another view which is reasonably possible undertaking. It is not very relevant, but repeatedly it is happening. So now the paragraph 63 is probably important for our case. However, we may clarify that a finding of fact based on, this is very much familiar, based on no evidence or purely on surmises and conjectures. This may kindly be considered. Right? No facts, no evidence, or purely on surmises or conjectures, or which are perverse points, would be challenged. So though the court should not, read court should not go through the factual aspects, but if it appears that the fact finding is perverse or finding is based on no evidence or finding is purely on surmises and conjectures, challenged by way, that could be challenged by way of certiorari, and as such finding could be regarded as an error of law. Though it is a question of fact, but it could be considered as a point of law. This has been pointed out. Yeah. Now, so conclusion that has been drawn at paragraph 64. Thus, from the various decisions referred to above, we have no hesitation in reaching to the conclusion that a writ of certiorari is a high prerogative writ, and it should not be issued mere asking. For the issue of writ of certiorari, the party concerned has to make out a definite case for the same, and is not a matter of course. To put it fitly, certiorari shall issue to correct the errors of jurisdiction. That is to say, absence, excess or failure to exercise, and also when the exercise undoubted jurisdiction, there has been illegality. It shall also issue the writ on error in the decision or determination itself. If an error manifests on the face of the proceeding, by its exercise, only a patent error can be corrected. That is very much more important. Only simple legal error should not be considered. Error must be a patent error. Only a patent error can be corrected, but not also a wrong decision. It should be well remembered at the cost of repetition that certiorari is not an appellate, but only a supervisor. This is very repeatedly they are saying so. This is a repellary jurisdiction. Now let's conclude by referring paragraph 65. This is a very, very good judgment. I am deeply obliged to your lordship to point it out for this judgment. A writ of certiorari, being a high prerogative writ, is issued by a superior court in respect of exercise of judicial or quasi-judicial functions by another authority, when the contention is that the exercising authority had no, exercising authority had no jurisdiction or exceeded jurisdiction. Two things, had no jurisdiction or exceeded jurisdiction. It cannot be denied that the tribunal or the authorities concerned at its batch of appeals had the jurisdiction to deal with the matter. However, the argument would be that the tribunals had acted arbitrarily or illegally and that had failed to give proper findings on the facts and the circumstances of this case. We may only say that while adjudicating a writ application for a writ of certiorari, the court is not sitting a court of appeal, repeatedly they are saying so, against the order of the tribunal to test the legality. Therefore, with a view to reach a different conclusion, if there is any evidence, the court will not examine whether that conclusion drawn from it or not. It is well-established principles of law that the writ court will not lie where order or decision of a tribunal or the authority is wrong, the matter of facts on merit, such and such and such. So these are the judgments, all the judgments, some of the judgments has been referred and came to the conclusion. And what I have understood, subject to your rectification by your lordship, that writ of certiorari is an extraordinary jurisdiction. It is to be exercised to examine the decisions of subordinate authority or the tribunal. While exercising this jurisdiction, the court will call the inferior authority to remit their records. And while remitting this record, they shall certify it, that these are the records for this word certification, the certiorari has come out. While remitting this record, they will certify the record and they will send it to the lordship to that extent that we came to the conclusion on the basis of this relevant record. Now, while exercising the jurisdiction of writ of certiorari, the court shall only look into the relevant record, and if the court found there is an apparent error on the face of the record, then and only then the court will interfere. Now, this apparent error in the face of the record may be of two kinds. One may be error of law and another may be an error of fact. Now, let us come to the point of error of law. If it is an error of law, then court can entertain it. But one thing that should be kept in mind, that every error of law will not give the jurisdictions of the court to entertain is writ of certiorari. The error of law, which is directly related with the jurisdictional error, that should be considered. Merely an error of law will not be considered, but error of law should be substantial error, and it must be an equitable error. It must be rectified through the equitable principles. Then and only the court must interfere. Every error of fact will not be considered by the writ court. But there are some errors of fact the court can entertain. What are those errors? If the tribunal came to a conclusion without considering any evidence, that is, facts arise based on no evidence. Secondly, if the tribunal came to a conclusion which is totally perverse. Perverse means a reasonable man who is instructed with some provisions of law will not come to this conclusion. Then and only then, though it is an error of fact, then the writ court will interpret. And where the tribunal or the court has interfered or had considered some inadmissible evidence, which is not relevant, then of course court can interfere. And another factor is that whether the tribunal was influenced by some consideration which is not relevant for the decisions. After saying all these things, the tax code specifically tell that there cannot be a straitjacket formula. Every fact, every case depends upon the facts of the tax year. This is the gist that I have understood, Lord. I've done and subject to correction by your lordship. And one thing is that this is a supervisory jurisdiction. And another thing is that the court will only inspect the document. When it is remitted to the court for its consideration, they should only inspect those documents. That has been specifically stated. Now, let us come to our case. Whether we can substantiate some points as we have understood here that can be attracted in this case or not. Now, before going to that, well, let me first come to this examination of read petition to the. So, for the jurisdictional error is concerned, now, when this tribunal, a reference was made to examine whether the person concerned is a foreigner or not. Now, in that reference, some documents were examined, annexed, which which encouraged the referring authority to refer this matter. And the court tribunal, while considering this case, must apply his mind whether this reference was proper or not. Preliminary finding, not very elaborate finding. That is a preliminary finding. And if this preliminary finding, there is an error or erroneous finding, then and only then the court can interfere. Not only then the court can interfere. Now, if your lordship come to the page 37, all these things are given. I'm not very much, well, on the last occasion I have pointed out, I will not repeat it again. Now, what was the finding of the inquiring officer who sent the matter to the referring authority for its adjudication, for making a reference to the tribunal? That your lordship will find at page 39, paragraph 16. Whether migrated into Assam, yes, oblique no. If yes, place from where he migrated, state, country, that is blank. Whether migrated before 1166, between 1166 to 24/3/71, or after 25/3/1971. These three dates are very much important, Lord. Before 11/1966, then he is entitled to reside in Assam for a period of 10 years, and after getting her name registered. And after 25/73, then he or she should be liable to expel from the Assam, state of Assam. There is no such finding in this regard. And it appears to me that the learned tribunal had not applied his mind to this document. Now, my on the last occasion, my learned friend has pointed out that case of H.R.A. Chaudhary versus Election Commission of India. Now, Milord, in that case, it was reported in 2002-1 GLT, page 1. तुम्हें मुस्लिम वाली चेष्टा होती तो बच्चे के बोलना होते वो किसको बुलाने Well, actually, exact page number I cannot say, my lord, but there is this paragraph number 3.8 of the decisions of this. I'm sorry, my lord, I have not brought that to
Not
your
required. You
GLT.
have the-
Hmm. क्या बात करोगे? क्या बात? Paragraph, probably paragraph 6 of that judgment, where the directives of the election commissions were recorded, relevant directives of the election commissions were recorded. Probably paragraph 6, or it may be paragraph 7 also. Imagine, no? Now, it appears that the Election Commission of India, hereinafter referred to the Commission, has issued instruction from time to time to the Chief Electoral Officer, Assam, for intensive revision of the electoral rolls in Assam, with reference to 1197 as qualifying date. These instructions of the commissions are contained in communications dated 7/10/19. Well, so let us keep it of those sources, copies of which have been annexed here, and the reply to the affidavit filed on behalf of the commission. The instruction of the commission, which provide that the cases of person whose citizenship is in doubt, are to be referred to the appropriate tribunals for determination of their citizenship, are contained in paragraph, these are very much, paragraph 3.8, 3.9, and 3.10 of the guidelines annexed to the communication dated 17/7/1997 of the commissions of the Chief Electoral Officer of the said paragraph 3.8, 3.9, and 3.10 are the guidelines are quoted below. I will simply rely upon the paragraph number 3.8. The electoral registration officer shall, on receipt of the verification report from the local verification officers, consider the same. The verification officer, I have just given the paragraph, page 37. Consider the same. Where he is satisfied on such report and such other materials, information as may be available to him about the eligibility of a person, he shall allow his name to continue on the roll and include it in the final roll. Where, however, he is not satisfied and has reasonable doubt about the citizenship of any person, he shall refer all such doubtful cases to any competent authority under the illegal migrant, that is very much important, Lord. Under the Illegal Migrant Determination Tribunal Act 1983, at that point of time, this act was in existence, and after Sarbananda Sonowal's case, this act is declared as ultra virus, or the Foreigners Act. Now, Lord, why these two things? So far, the 1983 acts are concerned, these are the illegal entrant, immigrant who entered in Assam after 1971. And so for the Foreigners Act are concerned, those who came to within 1966 to 71 or in between 66 to 71. So they must have a finding whether this person concerned has entered in the Assam after 1971 or before 1971. Finally, as the case may be, for convenience of the electoral registration officer, the Commission has devised a pro forma Annexure B for making such reference, which shall be adopted by all electoral registration officers. While making such reference, the electoral registration officer shall also furnish to the competent authority all documentary evidence collected during the process of verification, including local verification, etc. So what I am on before your lordship, an officer came and he has investigated the matter, and after investigation he sent his report to the concerned higher authority, and higher authority has sent the report to the referring authority, and referring authority had referred this case to the tribunal for its adjudication. So whether there is any material which is apparent on the face of the record to examine that he is a foreigner or not, or there is a preliminary conclusions or preliminary finding to that effect or not, that has to be considered by the tribunal. Now, my lord, Muslim, GLT policy, no?
Yes.
Now, your lordship, straightway come to Muslim Mandal case, Lord. That is reported in 2013 1 GLT 809. I will just refer some paragraphs. Paragraph 89 onwards, Lord. 2 or 3 or 4 paragraphs. I will refer.
Yes, please.
Look, first, your lordship come to paragraph 89. The tribunal gets the jurisdiction to give an opinion on the question whether the person is a foreigner or not, only when a reference is made by the authorities mentioned in clause 2 of 1964 order. The tribunal therefore has to cause service of the person to whom the reference relates a copy of the main grounds on which he is alleged to be foreigner.
Yes.
Alleged to be foreigner. The tribunal is also required to give reasonable opportunity of making representation. These are not very much important. Let me skip up. These are ordinary things. The tribunal, however, to provide civil code proceeding, etc. Civil procedure code will be available. These are things simply. So let me skip it up. Now, your lordship come to paragraph 97. Or I can read the entire paragraph of 89.
Yes.
Paragraph 91, etc. are not very relevant. These tells about the expert hearing. 92, etc. Now, paragraph 97 has some bearing in this case. Now, paragraph 97. Prior to that, there was a submission made on behalf of the proceeding that is contained in paragraph 96. As it is a submission of the proceeding, I will not refer it. I will just refer what is the finding of the court. Paragraph 97. The fair investigation and fair trial being the basic fundamental human rights of a person, which are concomitant to the preservation of the fundamental right of a person under Article 21 of the Constitution. There has to be fair and proper investigation by investigating agency before making a reference, but by making a reference to the tribunal. In such investigation, attempt has to be made to find out the person against whom the investigation is made, so that the person concerned is given the opportunity to demonstrate at that stage itself that he is not a foreigner. In case the person concerned could not be found out in the village where he is reported to reside, or in the place where he ordinarily resides or works for gain, the investigating authority agency has to record the same in presence of the village elder or the village headman or any respectable person of the locality, which in turn would ensure the visit of the investigating officer to the place where such person ordinarily resides or reported to reside or works for gain, and making an effort to find him out of the purpose of giving him the opportunity to produce the documents, etc. If any, to demonstrate that he is not a foreigner, the investigation officer, as far practicable, shall also obtain the signature and the thumb impression of the person against whom such investigation is initiated. After recording his statement, if any, provided he makes himself available for that purpose. There are also instances where the person against whom such investigation is initiated changes of places, residence, may be in search of the livelihood, he may be to avoid detection, to ensure the proper investigation, and also having regard to integrity and sovereignty of the nation. Once investigation relating to the nationality of the status of the person starts, he must inform the investigating agency in writing about the change of his residence, if any. Thereafter, in such case, person has failed to intimate the investigating agency in writing to the subsequent change of its place of residence. In the investigating agency, has two persons on the basis of the materials collected at the place where he earlier resided. That will ensure for investigation, a fair investigation and submission of a proper report on such investigation to the authority. Needless to say, such investigation need not be a detailed or an exhaustive one. Yes, it must not be detailed, but some things has to be done. Exhaustive one, keeping in view the nature of the proceeding before the tribunal, keeping in view the nature of the proceeding before the tribunal and the objects sought to be achieved. Hence, it need not be equated with the investigation conducted in criminal cases. Now, Miller, let's paragraph 98. The reference by the referral authority also cannot be mechanical. That is very much important. The referral authority has to apply his mind on the materials collected by the investigating officers. The material collected by the investigators, I have annexed it there. The investigating officer, by the investigating officer during investigation, and make the reference on being, that is very much important, on being satisfied that there are grounds for making reference. It is depend upon the referral authority. Now, whatever the duty of the tribunal, the referral authority, however, need not pass a detailed order recording of its satisfaction. An order agreeing with the investigation would suffice. The referral authority also, while making reference, shall produce all the materials collected during the investigation before the tribunal. And the tribunal is, this is very, very important. The tribunal is required prima facie to satisfy that I have already cited from the decisions of the Supreme Court, my lord, that is reported in 2023 online SCC, page 996, that there is a prima facie need of the tribunal to get himself satisfied that whether he has a jurisdiction or not. Though it was reported in 2023, but our High Court has already indicated in the year 2013. This is a landmark judgment, I should say, my lord. As the tribunal is required to prima facie satisfy itself about the existence of the main ground before issuing notice. So, the relevant records which were sent to the tribunal for his examination has to be looked into. And if he is satisfied, yes, there is a prima facie case, then and only then he will issue a notice to the proceeding. These, I will not refer to all these other things. What, by referring these 3 paragraphs, what I want to say, yes, you can investigate the matter, and after investigation, you can send it to your higher authority. Higher authority can send it to the referral authority, and referral authority has to send it to the tribunal. So there are some process of checking and rechecking. And when this matter comes up to the tribunal owes an obligation to consider whether there is a prima facie case or not. and while considering Sikhs before issuing a notice to this effect. And my respectful submission before your lordship that while the tribunal while examining the case has not examined this aspect of this case, had it been examined by him, had it been examined by him, he would not have committed this wrong error by issuing a notice. This is one limb of my argument, my lord. Now, my lord, let me come to the judgment itself. So my basic line of argument, because I will not trouble your lordship, because on that day I have read the judgment, some paragraphs. My basic thrust of argument is that this judgment to some extent perverse. And this judgment has failed to consider the admissible evidence. Now, your lordship may come straightway the judgment itself. No, should I read the entire judgment?
Not prepared, which one you want to like to show?
Yes, that will be better. Because on that day I have troubled your lordship by going through all these things. Now, what happened, my lord? Here, two or three or four witnesses were examined. Prosody examined herself. Prosody's brother examined himself, and that apart two other witnesses were examined. The Prosody's brother's contention was that she is my sister, and she, along with me, were brought up in our maternal uncle's house. And while we were residing in the maternal uncle's house, my name was figured in the voter list, and I have exhibited these two voter lists of 1966 and 1970. And now, this aspect of the case is a vital case, is the most relevant factor for consideration, but the learned tribunal has not considered this relevant factor. And as a result, he directed himself to an erroneous consideration. Now, my lord, straightway your lordship come to page number 23. I will not trouble your lordship because on that day I have already page 23. Now, second paragraph. OP has examined herself as DW1 and exhibited following documents like the A, B, C, D. Okay. C, D, E. These are the documents. Okay. OP has also examined one witness, Sri Ramendra Saha, DW2, as her elder brother. Now the point of determination is whether the opposite party is a foreigner within the meaning of Foreigners Act 1947. Okay. I have gone through the materials on record, written statement, evidence on affidavit, statement, and cross-examination of the opposite party, statement of the opposite party's witnesses and documents exhibited by opposite party very carefully. Now, decisions were there. In the voter list of 1966, village such Mondia LSC under LSC number 52, Bagbor Exhibit A, name of Ramendra Shah, that is my elder brother, is enlisted at serial number 271 in the voter list of 1970. The village of Mandia under LSC constituency, LSC number 22, Bagbor, the name of Ramendra Shah was enlisted at serial number 251. This is 1966 and 1970. These two voter lists were exhibited. Opposite party has claimed that this Ramendra Shah is her brother. opposite party has examined this Ramendra Saha as DW2, DW number 2. In his cross-examination, DW2 has stated that opposite party is his sister, that he does not know the residence of his father, that he, along with the brothers and sisters, brought up in the residence of the maternal uncle of the village Mandia, that he does not know from where and when his father came, that he does not know where such sister's opposite party was born. These were his cross-examination. From this cross-examination, what the conclusion drawn by the learned presiding officer, that has to be looked into. From the evidence of DW2, it can be established that opposite party's father and mother were inhabitants of Assam on or before 1966 or before from the evidence of DW2, it can be established that opposite father party's father and mother were inhabitants of Assam on or before 1966 or before 1961. This is his categorical finding. Now, after giving such finding, what he has said, from the deposition of DW, he has said so. And from the deposition, after saying so, what he said, from the deposition of DW2, it cannot be established that opposite party was born in the year 1952. At village Mandia, Exhibit D is a certificate issued by the Gao Panchayat Secretary of such and such number of Mandia village Panchayat, where it stated that Jyotsna Rani Saha, daughter of late Dinesh Chandra Saha, late Sarvabala Saha, mother, is inhabitant of the village Mandia, such and such, Assam. Is Assam known to him, issuing person. From the contents of the certificate of the opposite party's citizenship or her presence of citizenship cannot be established. Moreover, the truthness of the content of Exhibit T is not proved by examining the issuing person. Here he may be correct to some extent, because the document has to be examined by the author of the document. Certificate issued by the village headman of the village Mandia such and such, stated the name of Ravindra Chandra Saha, son of late Governor Chandra, village such and such. Now, from the document, opposite party cannot claim. Now, how should he have claimed to this document? This is not at all based on any reasonable ground. From the document, opposite party cannot claim that Ramendra Saha is her brother. Now, this brother is saying so that she is my sister, and the tribunal gave a positive finding to the effect that from the evidence of DW2, it cannot be established opposite father and mother were inhabitants of Assam. Inhabitants of Assam or not before 1971. It cannot be said. From the Exhibit E, neither opposite party can establish her linkage with Sri Ravindra Saha, nor she can claim that she is a citizen of India. As per Section 19 of the Foreigners Act 1946, the burden of the proceedings to prove by adducing cogent and reliable evidence that she is a citizen of India and not a foreigner. In this case, opposite party has not established her linkage with the projected father and mother, and she has not established that her father and the mother were inhabitant of Assam or on or before 1966 or between the period of 1966 to 71. Opposite party has also failed to establish that she acquires her citizenship by birth. Citizenship by birth. Now, here in this regard, if we go through the documents of the investigating officer, he has mechanically, he has said his place of birth is Borpeta Road. Mechanically, he has said so. If we also go through the page 37, place of birth is Borpeta Road. Had it been so, then it should not have been referred to this. All these things are mechanical. Opposite party has failed to establish that she requires citizenship by birth. In view of the above finding, the tribunal is of the opinion that the opposite party such and such is not a foreigner, is a foreigner of post 1971 scheme. He has came to that conclusion 1970. She be taken into the custody, etc., etc. This is the finding. No, my lord, what I am on, my lord, this finding is not only above beyond the jurisdiction by not examining the material on record. This finding is also perverse. And this finding totally ignored the admissible evidence of DW2. Well, this is basically my submission here.
Please take it.
Yes, what number, police. Tell them that, okay. গেছিল একবার, কখনো হয়নি। Bupati mone হয় হেঁটে এসে বারবার ফোন করে। Bupati, Bupati, Gase, বারো নম্বর যদি উঠে, 16 বারো নম্বর।
Yes, Mr. Pine.
My lord. Who issues, dear my lord? My
See,
lord,
basically, what Mr. Dasgupta has argued is that the LVO did not inquire into the matter, so it remained blank. And the ERO forwarded it. So relying on that particular paragraph
Para 90.
3.8 of the HRA Chaudhary, Mr. Nasgupta said that this what is the wrong in that. That is how it is wrong in the finding of the debt. And accordingly, the reference itself was bad. And the tribunal did not consider that aspect of the matter as required and issued the notice. He should have, before issuing the notice, he should have looked into it and then he should have issued the notice. According to him, this is one part. Second party, that the projected brother of the proceeding before the tribunal stated that the proceeding is his sister. This part of the evidence not being considered by the tribunal, the order is perverse. These are two parts.
Yes.
Now coming back to the Muslim bundle, para 89. Now that relates to the inquiry. But we must see that no doubt it's an inquiry that Muslim bundle case is on the basis of the police inquiry.
Police.
It is not on the inquiry of anything relating to the
Election,
ERO's
ERO,
report.
election.
It is purely an inquiry of the police inquiry. But my brother was also making some queries on this. See, basically, two types of reference.
Yes.
One is on the basis of police inquiry. Other is on the basis of
Electoral.
election. The competent authority, after getting such forwarding from the, either from the investigating officer, if it is a police inquiry, or from the ERO after if it's an through the forwarding by the ERO, look into it and needs to forward. Considering the entire judgment of the Sarvananda Sonowal 1, then the Muslim one.
Yes.
And HRA to make yourself.
First of all, my lord, as my learned senior friend was arguing, 2 points, my lord. One is perversity, one is the jurisdiction of the tribunal. Both things are there, my lord. So I'd like to go to my lord perversity first. My lord, the opinion of the tribunal, my learned senior friend was arguing, that opinion of the tribunal is based on no evidence and based on my lord, some evidence, though there were evidence, those were not considered by the tribunal. So tribunal has given some perverse my lord, findings, so it is bad. First of all, my lord, I'd like to show my lord, what is the burden in these cases, my lord. Under the section 9 of the Foreigners Act 1946, my lord, the burden is casted on the petitioner to prove that he is a citizen of India, notwithstanding anything contained the Evidence Act, my lord. It is the burden of the petitioner proceeding to prove that he is a citizen of India. And how to prove? That is in para 26 of the Sarvananda Sonowal. What are the necessary things, my lord? To prove in para 26, it is clearly said, my lord. Because, my lord, we have 2005 SCC, my lord, 665 and para 26, Sarvananda Sonowal. What things are to be proved, my lord? That is the main issue. What things are to be proved in the my lord tribunal for establishing a citizen. Para 26, I'm reading that part, my lord. There is good and sound reason, the burden of proof as well as the my lord. There is good and sound and sound reason for placing the burden of proof upon the person concerned who asserts to be citizen of particular country. This is not only applicable in India, my lord. This is applicable for other countries also, USA, and even my lord, the Britain, they're following the same procedure. And on the basis of that only, this, after discussing all these things, these findings has been given, my lord, by the Honorable Apex Court. In the best of particular country, in order to establish one's citizenship, normally he may be required to give evidence of number one. There are 3 points, my lord. Number one, his date of birth. Number two, place of birth. Number three, name of his parents. Number four, their place of birth and citizenship. And number five, sometimes the place of birth of his grandparents may also be required. So, what are the things to be proved by the city by proceeding? Is number one, his place of date of birth or year of birth. We accept, my lord, even though it is not date of birth, year of birth, it is enough. For our sake, my lord, year of birth, the place of birth, the citizenship of the parents, their names, and in some cases, my lord, citizenship of the grandparents. These are required. Then it is also said, my lord, then once they gave the evidence, the state may revert if necessary. My lord, if necessary, that is the thing. If not necessary, state may not revert on that. So that is the point in para 26. Someone understand. So we have to see, my lord, the section 9 of the Foreigners Act provided that it is the burden of the prosecutor to establish, prove the case. And what are to be proved? My lord, it is in para 26. Now, on this point, what the petitioner, the proceeding has brought before the tribunal, man. Let us see the evidence of DW2. What he has in the cross, my lord. I'm just relying on the cross part of the DW2, page 30, my lord. There is no purpose. My submission is there is no perversity, my lord. That's why I'm showing this. What he has stated DW2 in cross, my lord. The opposite party is my sister. She is about 5-6 years younger than me. My mother name is Soroswati Saha. My father died in the year 1965. My mother died after 2 years of my father. I could not collect the name of my father's father. That is my grandfather, which is a necessary aspect, necessary things to be proved by the proceeding as per para 26. Even the respondent.
Mr. Pine, just a break. Most of the children nowadays doesn't know the name of their grandfathers and grandmothers.
That is one aspect, just I'm pointing out.
That you'll see when you go to the cremation ground. As per Hindus, you know that you have to fill up the form and you have to say that name of the grandfather. So most of the children, they will not
They
know the
don't know.
names of their grandfather.
Generally, it's. But I'll at that time.
It's fact, that's why this is not a one on many.
My
of
mother
things I
died.
have seen.
Yes, just I'm pointing out that part, madam.
Yes.
But it is a necessary as per. It is necessary as per law. So what? That's why I'm submitting. I could not recollect the name of my father's father, which is my grandfather. I could not recollect the name of my grandmother. He could not say who is the grandmother. It is fact that in my evidence I did not mention that my father was the only son. I could not say where my father's house. He should know at least his father's house. Me and my brothers and sisters were brought up by our father, by our maternal uncle at his house in Mandya. I could not say when and where my father, where from my father came. I could not say, my lord, where and when my sister was born. I could not say when I was born. I could not say where my parents casted vote or their vote. I casted vote in the year 1966 and it is still casting my vote. So he, on each and every case, my lord, he suggested he could not see the place of birth of her sister, year of birth of her sister. He could not see who was the grandfather, who was the grandmother. He could not say where the father, from the father came, where the father was born. He did not know anything, man. And this is the findings. On the basis of this only, the tribunal has given his opinion. Tribunal has clearly, tribunal has, that's why I said, from the document in finding decision in page 23, my lord. Page 23 of the decision and reasoning, my lord. There it is said, from the evidence of DW2, it cannot be established that Popi's father and mother was inhabitant of Assam on or before 1/1/1966 or before 1971. Where is the evidence that the parents were there prior to 1966 and 70? That is true. That neither the DW2.
Is it required that parents should be in India? Or the Prosody himself may be in India?
My lord, there are two things. First of all, that's why, my lord, the para 26 says, first of all, his date of birth. If he can establish, the person can establish that he was born in India prior to 1971, then there is no necessity that, my lord, parents should be from should reside in India. That is the issue, my lord. First of all, that's why it is said, his my lord, why date of birth is necessary, my lord? Because we have the cutoff date. 1166, 1171, 25/3/71. So if the petitioner was born, and if he could establish that he was born in India prior to 1/25/1971, that matter ends in that itself. If he fails, now in the present case, the petitioner could not establish that he was born in India prior to 25/3/71. Where is the document? Where is the evidence to show that he was born in India? That's why place of birth, year of date of birth is. That's why Sarbananda Sonal has firstly said, first issue is place of date of birth and place of birth. That has to be proved. If it is proved that a person is born in India, that's enough. Where is the evidence to that effect? And it is the duty of the petitioner to prove that he was born in India prior to 71, or he was born, even though, my lord, if he is born after 71 also, he has to prove that he was born in India. Where is that evidence? First of all, if she fails to establish that he was born in India, then in that way, in that manner, he has to establish that his parents were Indian, who were there in India prior to 1971, and then being son or daughter of that person, I'm also Indian, even though I don't have birth certificate or I don't have the proof of my birth. Then he has to establish through his parents that my parents were there in India prior to 1971. So I'll be.
No, here the procedure did not state regarding our parents, but what procedure say that our brothers.
Matter I'm coming to that. Now, the lineage doesn't come through brothers, my lord. Brother may come yesterday, I may come today. That is the findings in the, my lord, the Abdul Quddus also. That's why Abdul Quddus, it is said, every case, facts and circumstances is different. One may come prior to 1/1/25/1971, one may come later also. So their cases will be different footings, my lord. So I'm not saying, and secondly, my lord, even though I accept that he is the brother of the petitioner, my lord, our question is that if brother was in 1966-70, and brother is a citizen of India, the brother, if she could prove that yes, they have linked documents, and the second thing is linked documents. Where is the linked documents of the brother and sister? That is why the tribunal has said, from the documents submitted by DW2 and DW1, that is the petitioner, it cannot be said that the petitioner was son and daughter of that parents whom the petitioner is claiming. So this is the issue, simple issue, my lord. We may go into, if we go in deeper.
This second part,
Yes.
regarding the perversity of the judgment.
Yes.
Now come to the first claim of argument of Mr.
First line is, my lord. First line, I like to say, my lord. First of all, my learned senior friend was reading that para 98 of this, my lord, Muslim Mandal. My lord, in fact, this issue has been settled times and again by this honorable court. Para 98, just I'm reading out entire para 98 because next part of the para 91 was not read out. That's why I'm saying, madam. I'm relying on para 98 of this national once again. The reference by the referral authority also cannot be mechanical. That is true. The referral authority has to apply his mind on the materials collected.
Which para?
Para 98 of this the Muslim Mandal.
Yes.
Collected by the reference by the referral authority also cannot be mechanical. The referral authority has to apply his mind on the materials collected by the investigation officer during investigation and make the reference on being satisfied that there are grounds for making such a reference. The referral authority, however, need not pass detailed order recording his satisfaction. An order agreeing with the investigation would suffice. The referral authority also, while making the reference, shall produce all the materials collected during the investigation before the tribunal, as the tribunal is required from prima facie satisfied itself about the existence of the main grounds before the issuing of the notice to the proceeding. That is true, Mike. The referral authority has to satisfy. But it doesn't mean he should record everything that, yes, for this reason, I'm satisfied. This has been clarified later on also by numbers of judgments, my lord. And second thing, my lord, one thing we have to remember, my lord, the entry judgment of this, my lord, Muslim Mandal is based on police inquiry. This is based on different facts and circumstances. And in the present case, it is in the different facts and circumstances. So before going to this, my lord, I would like to point out my lord, your lordship may kindly see the petition itself. In the petition, my lord, if your lordship will see, there are 2-3 forms. Then your lordship will understand the entire system of investigation.
A and B.
My lord, yes. A and B. Your lordship will find the
Page 37.
page 34, my lord. But 34 is the B form. B form will clarify how a Muller form has come up. In B form, my lord, it is said, it is referenced by the electoral registration officer, ERO. My lord, your lordship will find, whereas the Election Commission of India has ordered an intensive revision, electoral rule for the 40 Sorbuk Assembly constituency in Assam, with reference to 1197 as qualifying date. So 1197 was the qualifying date. And whereas the house-to-house enumeration was done during the period of 16 January 1997 to 15 April 1997. But there was a house-to-house enumeration. This is a different part. House-to-house enumeration is a different issue. Then, whereas the name of Sri So-and-so, my lord, the petition procedures, wife of So-and-so was declared to be an Indian and as also an ordinary resident of So-and-so has been enumerated for inclusion in the draft electoral roll. So the petitioner's name was included in the draft electoral roll in 1997 after the house-to-house enumeration. That is the issue, my lord. Whereas the electoral roll of the state constituency was published on 24/7/1997, including the name of the said Srimati so-and-so. Her name was included in 1997, my lord. That total is. Whereas I, the electoral registration officer for the state assembly constituency, having doubt about the citizenship of India person, got the matter verified by an on-the-spot local verification. This is second part, my lord. First, house-to-house enumeration. Then there is a doubt in the mind of the my lord, electoral registration officer. Then to clarify the doubt, my lord, he made the verification was made by the local verification officer. Whereas on consideration of the report of such verification, I have reasonable doubt that she is not a citizen. Now, therefore, the matter is forwarded to SP Board for my reference. So this is the sequence, my lord. The sequence is first, there was a direction from the Election Commission of India for my lord, the extensive revision. There was an enumeration, house-to-house enumeration. Then, my lord, the draft list was published when the petitioner's name appeared. Then, my lord, due to some reason, the electoral registration officer cast a doubt. So to clarify the doubt, my lord, as 3.8, my lord, I have read out, my lord, so to clarify that doubt, the ERO asked the local verification officer to make a, my lord, report. And if, as I said, my lord, 3.1 has clearly said, on being satisfied, if the electoral registration officer is satisfied on the basis of, my lord, on the basis of local verification officer's report that his name can be continued in the voter list, he will continue the name of the petitioner or the proceedee in the voter list as his name was existing or her name was existed in 1997 voter list. That is the, my lord, background. Now, my lord will see that there was notification. In fact, that notification I had earlier submitted, but that was of 2005. My lord, that is exactly same,
Similar as
similar to 1997, but dates only the cutoff dates.
97 notification is
Yes,
considered in the HLH.
yes, not 97 notification was considered. My lord, I would like to just read out from the 97 notification to Chief paragraphs, but I don't think it is there along with your lordship. I will read out, my lord, slowly. My lord, the 3.7, in fact, these are the same in that, my lord, 2005 notification. Only the points are different. The point, my lord, the item numbers are different in that case. 3.71 in the, my lord, 1997 notification it is. So first, person of mention, my lord, there were two categories of person mentioned. I'm reading out another part, my lord. So first, person mentioned in 3.61 above, who have attained the age of 18 years, as on 1st January 1997, are concerned, their names may be straightway included in the final rules, provided there is linkage through father, mother to the existing rules. So in their names should be included directly in 1997, provided their father's name should be there in some electoral rules and linking herself or himself to the existing rules, some existing rules. No? In case no such linkage can be established, the electoral registration officer shall cause a local verification to be made as prescribed herein in the forthcoming paragraph. So if he cannot establish, my lord, his link, then, my lord, these local verifications were made. Number 3.7.2, my lord. In the case of persons mentioned in 3.6.3 above, who have entered in from Bangladesh in between 1196 and 24/3/1971, that's why, my lord, as because this classification was there in 1997, this notification, that's why, my lord, the format also contained the same, my lord. 24/3/1997, and have completed a period of 10 years from the date of their detection as foreigner, their name be included straightway in the final rule as per provisions of law under section 65 of the Constitution Citizenship Act 1955. In all other cases of persons mentioned in para 3.6 above, the electoral registration officer shall cause a local verification to be made by local verification officers. The local officer whose service the electoral registration officer may use in this regard would have the prior approval of the chief electoral officer. They are not our officers, my lord. They are hired from, my lord, government, and it needs the approval of the Chief Election Commission of India. In no case, teachers will be appointed as local verification officers for the purpose, nor should any officer who was actually engaged in the physical enumeration work in the area be engaged as for this purpose. So those who have earlier engaged for the purpose of, my lord, enumeration, they will be not included as local verification officer. So they are totally different from the electoral registrations office. They are hired from government. The local verification officer will conduct the verification by making on-the-spot visit, and the person concerned may adduce in support of his claim as a citizen of India any or more of the following documents of the evidentiary value under the Indian Evidence Act. So while verifying the petitioner, the proceeding has to produce the following documents. documents have been noted. Some documents have been noted here. This document has to be produced by the melody, the person concerned against whom the verification is made. Number one, certified copy, extract of electoral rolls of 1966 or any previous year. These are the documents, my lord, which were included in NRC updation process also. These documents were included. Number two, Patta land holding record, land receipt issued by any revenue authority, certified copy of entry in the NRC, registration for citizenship, birth certificate under the date and birth registration, citizenship certificate issued by any competent authority in the state of Assam, citizenship certificate issued from outside the state, which all should be got verified from the issuing authority, refugee certificate, registration certificate, passport issued by the government of India, insurance policy, any license issued by any government authority other than ration cards, documents showing service, employment under government public sector undertaking, certificate issued by the secretary to the village panchayat, countersigned by the local revenue officer in respect of the females who have migrated to their village after marriage. This is what Rupjana Begum has clarified again, my lord. Any of the documents relevant and admissible under the Indian Evidence Act that the electoral registration officer may consider fit to dwell upon the make of his mind on the question of citizenship. These documents have to be collected by the local verification officer. If he can collect, the local verification officer can collect these documents and submit before the ERO. ERO may consider, and then if he's satisfied, he can continue their name. If he is not satisfied as per 3.8, my lord, he will forward the matter to the Foreigners Tribunal for a reference, refer the matter for an opinion. My lord. So now, my lord, what the local verification officer has collected from my lord has, which we can see from B, my lord, the page 37, annexure A, my lord. This is annexure A. This is by the local verification officer. Format for verification officer's report to the electoral registration officer. As desired by you, I have made necessary verification. This first letter itself says, my lord, verification in respect of Srimati So-and-so by making an on-the-spot visit. My verification reveals the following particulars in her class: name, Jyotsna Rani, address, BPRD, ward number 3, father's husband's name, Labu Saha, date of birth 50 years, place of birth BPRD. Now, para 7, my lord. If so, whether registered as an electoral or any constituency in India. If so, serial number and part of the concerned electoral rules together with constituency number named the state. The state, my lord, no evidence has produced. The petitioner has not produced any documents, any evidence before the local verification officer. And if the petitioner fails to produce any document, as indicated, my lord, the local verification officer submitted this report, and this report is not enough for the electoral registration officer to reverse his the opinion or reverse his doubt that yes, this petitioner's name can be continued in the voter list of 1997. So in that case, he used to put the name D against her name, and matter forward in due course of time, matter is forwarded to the SP concerned for reference. Then SP, according to SP, refer the matter, page 41. Page 41 is the reference made by the Superintendent of Police on the basis of the ERO's report. So the tribunal has considered all these things, Tribunal has considered everything, all these things, and then only the tribunal has issued the notice. Then only tribunal has considered, referred the matter. Tribunal has issued a notice. For reference, your lordship may kindly see another judgment of this honorable court. That day I have referred the HRS Chaudhary case, my lord. In fact, while my lord, the preparation of this, my lord, the notification of 1997, the case of Lal Banu, decided in 1995 in the Honorable Apex Court, that was considered by the Election Commission of India. And considering that only this, my lord, guideline of 1997 was framed. In Lal Banu, I will, my lord, like to give the reference, my lord. That is. Death judgment is, my lord.
The judge,
1995 3SCC, my lord, the judgment. 1995 3SCC, page 100, my lord. Lal Babu Hussain and others versus electoral registration of officer and others. And considering all this aspect, only the 1997 the notification was published, and accordingly that was silenced, and again that was, my lord, affirmed by this honorable court, and Honorable Apex Court has dismissed that, my lord, appeal. There was no specific order, my lord, but that was dismissed in the mind.
Mr. Payang, just tell us one thing. All these, when the 1983 Act was in, all these,
Yes,
but when that Act has been
that
cut
is,
down,
yes,
and what?
that is
Can
another,
you tell us what?
that is another issue, my lord. In fact,
See, the Sarvananda Sonowal is very clear.
yes,
The matters pending before the tribunals referred under the IMDT has to be now considered tried under the Foreigner Act.
foreigners.
In that circumstance, what will happen with all these
My lord,
inquiry and everything?
my lord, I would like to refer the paragraph 83, my lord. What exactly the Honorable Apex Court says in Sarvananda Sonowal. To sum of our consideration, the provisions of the Illegal Migrants Determination Tribunal Act are ultra vires, the Constitution, and are accordingly struck down. The Illegal Migrants Determination by Rules 1984 are also ultra vires and are struck down. As a result, the tribunals and the appellate tribunals constituted under the Illegal Migrants Tribunal Act 1983 shall cease to function. The Passport Entry into India Act 1920, the Foreigners Act 1946, the Immigrants Expulsion from Assam Act 1950, and the Passport Act 1967 shall apply to the state of Assam. All cases, my lord, all cases pending before the tribunal under the Illegal Migrants Tribunals Act 1983 shall stand transferred to the tribunal constituted under the Foreigners Tribunals Order 1964. So all tribunals cases which were pending before the foreigner tribunals under the IMDT Act, those will be transferred to the Foreigners Tribunal and shall be decided in the manner provided in the Foreigners Act. Now, my lord, this aspect, the all matters which were pending before the Foreigners Tribunal, the IMDT Tribunal, those will be transferred to the Foreigners Tribunal, and it will be decided as per the Foreigners Act 1946, not as per the, my lord, IMDT 1943, 1983. I will come to that point again, my lord. The rules made thereunder and the procedure prescribed under the Foreigners Order 1964. In view of the finding that the competent authority and screening committee have no authority or jurisdiction to reject any proceeding initiated against any alleged illegal migrants, the orders of rejection passed by such authorities are declared to be void and not as in the eye of law. There are two points. Yes, ma'am.
You first read 79, right?
83, ma'am. 83, ma'am. This point has to be argued, my lord. In fact, this point should have been argued long before. Even though this was pointed out 2-3 occasions, actually, and this was not properly decided.
See, what the read para 83 because it has a.
Yes,
bearing on it.
Yes,
That is the
para
reason we are
83,
asking you.
yes, that's why, my lord. I'm reading para 83 itself. So, my lord, your lordship will find 83, my lord. To sum up our conclusion, the provisions of Illegal Migrants Determination Tribunal Act 1983 are ultra vires. The Constitution are accordingly struck down to the Constitution and accordingly struck down. The Illegal Migrants Determination by Tribunal Rules 1984 are also ultra vires and are struck down. As a result, the tribunal and the appellate tribunals constituted under the Illegal Migrants Act 1983 cease to function. The Passport Entry into India Act 1920, Foreigners Act 1946, the Immigrants Expulsion from Assam Act 1950, and the Passport Act 1967 shall apply to the state of Assam. Now, all the cases pending before the tribunals under the Illegal Migrants Determinations by Tribunals Act 1983 shall stand transferred to the tribunals constituted under the Foreigners Tribunals Order 1964. This is under Foreigners Act 1946, my lord, and shall decide in the manner provided in the Foreigners Act, the rules made thereunder, and the procedure prescribed under the Foreigners Tribunals Order 1964. Now, my lord, it is clearly said the 83, it is ultra vires, it is set aside. So now, whatever matters pending before the tribunal in the that will have to be tried on the basis of the Foreigners Order 1964 and Foreigners Act 1956.
Now,
Now-
just tell us, that is the reason we are asking you.
Yes.
When the Honorable Apex Court in the Surrender Sonwal 1, a bench constituting of 3 honorable judges has specifically directed that the proceeding will be under the provisions of the 1964 orders, the act and the rules framed thereunder. Is there any requirement?
That's why that I'm coming to that
That
point.
is more important.
That's why, my lord. That's why the form 2, my lord, what the form 2, form A, form B, and
Have
form
become redundant.
that become redundant. That is also discussed in the same judgment. I would like to show your lordship, para 41. Why these are not necessary? Why these documents, my lord, your lordship will find para 41, para 42. My lord. Why this form 2, 3, sir, 3,
Which judgment you're talking?
same Sabananda Sonal, my lord. This is discussed. Then, my lord, it is said later. Because these forms are, my lord, they are in the IMDT order.
That's right.
These forms are part of the IMDT tribunal and IMDT order. So these forms, the Honorable Apex Court has said, the materials which were to be collected by these officers are, my lord, not
Yes.
possible.
41.
my lord. From page 40, para 40, my lord, I'm just reading out. It is very important to note here that IMDT Act does not contain any provision of similar to Section 9 of the Foreigners Act 1946 regarding burden of proof. On the contrary, it is conspicuously silent about it. In such circumstances, a very heavy burden is cast upon the authorities of the state or the applicant to establish that a person is an illegal migrant as defined in the Section 31C of the IMDT Act and is liable to be for deportation. Rule 4 requires an inquiry officer to elicit information, the forms requires information and particulars from the alleged illegal migrant on the points mentioned in form number 1, item 5, 10, 12, 11, 12 of the form as under. These are the matter. Address of the country of origin, village, police station, district of the country. This, my lord. Number 10, does the person hold any passport issued by the foreign country? If so, furnish particulars. 11, what are the reasons for leaving the person's country of origin? Number 12, if the person has entered into India without passport, how the person entered in India? Name of place, district from which person entered, date of entry. It is elementary that a person who has illegally come from Bangladesh to India and is residing here for his better economic purpose or employment, etc., would never disclose that he has come from Bangladesh, but would assert that he is an Indian national and resides in India. He will not disclose all these things. There is no question of his telling his date of entry or giving any information on the aforesaid points. According to the rule 7(8) of the rules, the inquiry officer has to submit a report in form number 2, that is number. And item 5, 10, 11, 12 are exactly identical to that in the form number 1. Rules 10, 10A, 10B lay down that an application to the tribunal under section 8(2) shall be made in form number 3. An application to the central government under section 8(2) shall be made in the form number 5, and declaration under section 8(2) shall be made in the form number 5 and form number 4. 6. Curiously enough, the column number 6, form number 3, requests the applicant to furnish the following information regarding the alleged illegal migrants. So the information whether he entered in India on or after 25/3/1971, date of his entry into India, whether he is a foreigner, and whether he entered in India without being possession of valid passport or travel document or lawful authority on behalf. This is discussed, my lord. This is just indicated. This is said, the Honorable Apex Court has said, this is not possible to collect from the informed persons who has entered in India illegally, and he will disclose all these things that I have come due to this reason, this reason. So this was part of the foreigners, the IMDT Act, and that was set aside. And second part, my lord, in the same line, it is also said, after setting aside, it is said the tribunal, the matter shall be stand transferred to the tribunals constituted under the Foreigners Tribunal Order 1964 and be decided in the manner provided in the Foreigners Act, my lord. This part has to be seen. What is there in the Foreigners Act? Foreigners Act says, my lord, your lordship will find the Foreigners Act, in the Foreigners Act, how is to be decided, whether any inquiry is to be made in the Foreigners Act or not. That is there, my lord, your lordship will find in the Foreigners Act. Foreigners Act section 3, Foreigners Act 1946.
Yes.
The Foreigners Act section 3, my lord, says the central government, section 3 of the Foreigners Act 1946, the central government may by order make provision either generally or with respect to all foreigners or with respect to the particular foreigners or any prescribed class or description of foreigners for prohibiting, regulating or restricting the country of foreign into or their departure therefrom, their presence or continued presence therein, in particular without prejudice to the generality of the foreign powers orders made on. Under this, my lord, the Foreigners Order,
Section 3.
section 3. So it is the central government may by order make provision either generally with respect to all foreigners or with respect to any particular foreigners or any prescribed class or description of foreigners for prohibiting, regulating or restricting the entry of foreigners into or their departure therefrom, the presence of the or continued presence therein. And this, on the basis of this, my lord, Foreigners Tribunal's Order 1964 was constituted. Now your lordship will see the Foreigners Tribunal's Order 1964. Section 2. On the basis of that Foreigners Tribunals Act, my lord, section 3, the Foreigners Tribunal Order 1964 was constituted formed, and this Tribunal's Order 1964, section 2(1), my lord. This will be clear. The central government may by order refer the question as to whether a person is or is not a foreigner within the meaning of Foreigners Act 1946 to a tribunal to be constituted for the purpose for its opinion. It is the discretion of the central government, my lord. The central government may by order refer the question as to whether a person is or is not a foreigner within the meaning of the Foreigners Act 1946. The central government has empowered this, my lord, not power, to the state government in case of state of Assam, my lord, and this is delegated to superintendent of police for reference. And as per this provision, my lord, there is no necessity of inquiry as such. This provision has said the central government may by order refer the question as to whether a person is or is not a foreigner within the meaning of the Foreigners Act 1946. There is no question of, my lord, making an inquiry prior to making this reference. The entire process, if your lordship will go through, if your lordship see the, my lord, the notification of the election commission, my lord, your lordship will find the entire process itself is inquiry process. The tribunal is not differentiated from the, my lord, electoral register's office. If you see, my lord, the entire process is this. The central government may by refer the refer the question to whether the person is not a foreigner within the meaning of the Foreigners Act 1946.
You read the later part of para 83 in the second half.
Yes, second part is the, my lord.
We'll come back at 2 and read this second part of para 83.
Yes.
That will more clearly lay down everything. Thereafter, we'll take up your case.
Lordship, I just one small favor, sir. I have some personal difficulty today. Can be a day after tomorrow, my lord.
Okay.
My lord.
Break it over from that where as so next part on item number 2. We'll come back at 2.
It's not otherwise inconvenient, my lords, can they be taken up on next Tuesday, my lord? 11.
Good. 18th. As of now, 18, there are no cases.
That's if I may very humbly request, can they be top of the list matters, my lord, because they're previous
We
matters
make a mention in the morning.
in the morning? Yes,
That will
my lord,
be-
I'll mention for upgrading,
But we have seen that as of 18, we do not have any cases.
certainly,
On 28th, we have one case.
yes.
So
But maybe on both of those days, my lords, if they can be disposed of. my lords. I'm grateful, my lords. 18th. Grateful. Very good.
maybe shocked with the results.
Probably, probably. Actually, it was my fault. On that day, your lordship pointed it out. I thought it,
It's
no.
They had
Then I insisted your lordship to
Nice,
take it
good.
today.
We are not involved with all those things. But to certain extent, it is not there. It matters because the difficulty is, the High Court and the other institutions of the High Court have to ask for money to the government. And normally we do not spend extra. They're very specific. But every time you go on begging the government for the fund, it is difficult for us. Being a High Court, say for the university, for the academy, no doubt, we have, if our demand is 50, they can give only 24 or 26, but they are also, state is having the financial crunch. Like we need to have the courts. Say, for example, the CGM court in it's in a very bad shape. A judicial officer sitting in such position, it is difficult. Myself with brother earlier visited the Karimganj district and session judge office. Not possible for any human being to,
Yes, it's a deplorable condition.
very, very sad. Now the judicial officers have to render justice from that kind of. So these are the things, every time you have to ask, we cannot have the building as per our requirement. We'll be giving our requirement. The thing is this, that's how sometimes, they are giving us, but we have to beg. Basically, that is what is difficult for us sometimes. They are giving us their listen and comparatively, see, the Northeast are not so rich like Punjab or Haryana or others because the revenue has earned more. That's what they can give, they can provide. But for us, the northeastern states, resources are not that can fulfill everything. They have to, most of the cases, they have to look after the central government. But say for Nagaland or for Mizoram, these are the things, and where from they will generate the revenue. First of
These are practical problem.
And taxes is also less in those states. At least Assam has the tax, but comparatively the hill states, as you know. There are things like that. So it depends. That is why the government is also at the same time very important for the running of the institution, the national institutions, or the other government institutions. We feel that way. But otherwise, whenever there is a demand, they are willing. But thing is this, we can also understand the financial crunch, the financial pains there. So, pursuant to the decision of the Honorable Apex Court, the judicial offices now are getting some financial benefits. The other states have already given. In fact, Tripura and other states they have given because they have the resources directly from the central government. But state like Assam and all, they could not fulfill entire things as of now because of the finance. These are the reasons I say. Anyway, let us proceed. Yes, Mr. Payang.
So my submission is, Madam, first of all, the Foreigners Tribunal Act and Order 1964, both does not provide any kind of inquiry prior to sending the matter or prior to giving the matter prior to refer the matter to a tribunal for its opinion. Madam, if your lordship may kindly see, one thing your lordship will find in the, my lord, if your lordship has the compilation of that, my lord, Election Commission of India that they have provided. In fact, that is, my lord, that is reflected in the HRA Chaudhary judgment also, under the para 2, 3, and 4, para 8. Just I'm reading out. That part is has some importance, matter in this case. Because if you read the entire paragraphs, matter from para 3.8 to 3.10, your lordship will find.
2002, right?
Yes.
1.
2002, 1 is 1 GLT 1. You may read this para 3.8 and 3.9.
2001 GLT, no?
1 GLT. This is 2 GLT. No, 2000.
1 G.
1 GLT page 1.
Yes, 1 GLT page 1. This method 3.8, I am not on other aspect, only this method inquiry part method. The electoral 3.8 method, in fact, I wanted to rely that
97 notification.
97 notification only. This is part of the notification.
Hmm.
The electoral registration officer cell on receipt of the verification reports from the local verification officer consider the same where it's satisfied on such report and such other materials information as may be available to him about the eligibility of a person, he shall allow his name to continue in the role and include it in the final role. Where, however, he is not so satisfied and has a reasonable doubt about the citizenship of a person, he shall refer such doubtful cases to the competent authority under the Illegal Migrants Determination Tribunal Act 1983 or the Foreigners Tribunal Act 1946, as the case may be. The competent authority here is the SP concerned. For the convenience of electoral registration officer, the commission has devised a pro forma Annex B matter for making such reference, which shall be adopted by the electoral registration officer. While making such a reference, the electoral registration officer shall also furnish to the competent authority all documentary evidence collected during the process of verification, including local verification report pertaining to the person concerned, and also inform the person concerned of his case having been referred by him to the competent authority. That is with regard to my lord verifications report. 3.9. After the case of the person has been referred by the electoral registration officer to the competent authority, as aforesaid, he shall wait for the decision of the relevant tribunals in relation to that person and act according to such decision. Well, this part has some bearing because once the matter is referred by the electoral ERO to the competent authority, he shall wait for the decision of the relevant tribunal in relation to the person and act according to the decision. You wait for the decision. This is the entire process is under this section 2 only. This process is not ended, my lord. The process initiated by the electoral registration officer, it will end by himself only after getting an opinion from the tribunal. This is only for an opinion. This is sent only for an opinion, my lord, for an opinion. 3.10, my lord. Where the relevant tribunal decides that any such person is not a citizen of India, the electoral registration officer shall proceed under Rule 21 of the Registration of Electoral Rules 1960 to have the name of such person deleted from the electoral roll before it is finally published. The electoral registration officer shall issue notice or as required under the provision of said Rule 21 of the Registration Electoral Rules 1960 to the individual concerned in the prescribed format. If further appears that by an order dated 5/1/1998 of the Commission, copy of which has been annexed to the reply affidavit filed on behalf of the Commission, it has been directed that persons whose name have been provisionally entered in the electoral rolls in the state of Assam and against whose name the letter D has been indicated to denote that their citizenship status as doubtful or disputed shall not be allowed to cast their vote at the ensuing general election to the House of the People, and also at any election held thereafter, either to the House of the People or to the Legislative Assembly of the State of Assam, so long as the citizenship status of any such person is not determined in favor of the appropriate tribunal to whom his case has been referred. For the aforesaid direction of the Commission, reasons have been also recorded by the Commission in the said order dated so and so. Portions of the said dated order dated so and so, which contain the direction and the reasons and which are relevant for the deciding case of as are put here in under. No, my lord. Whereas the Commission has carefully examined the question and observation that 326 of the under 326 of the Constitution, the elections to the House of the People and the Legislative Assembly of the every state shall, on the basis of adults suffrage, that it is to say every person who is a citizen of India and who is not less than 18 years of age on such date as the case may be fixed in that behalf by or under law and made the appropriate legislature and is not otherwise disqualified under the Constitution or any law made for the appropriate legislature on the ground of non-residence, unsoundness of mind, crime or corruption, or illegal practice shall be entitled to register as a voter at any such election. And whereas Section 16 of the Representative of Voters and any such Act 1950 further provides that a person shall be disqualified for registration in electoral roll if he inter alia is not citizen of India. And whereas Section so and so of 1951 provides that no person shall even if his name is for the time being is entered in the electoral roll or any constituency of any constituency voted any election in any constituency, it has, if he is subject to any of the disqualification referred to Section 16 of the RP Act 1950, and whereas the conjoint reading of the above referred Article 326 of the Constitution, Section 16 of the RP Act 1950 and Section 62 of the RP Act 1951 leaves no one in any manner of the doubt that only citizen of India alone and no one else is eligible to vote at elections to the House of the People and the state legislative assemblies, and therefore, whereas in the light of the above unambiguous mandate of the Constitution of India, RP Act 1951, that only the Indian citizen alone and no one else shall vote at the aforesaid elections. It logically follows that a person whose citizenship status is in question and under consideration before foreigner tribunals or in the illegal migrants tribunal shall not be eligible to vote unless such tribunal decides in his favor that he is a citizen of India. Now, therefore, the Election Commission of India, under its plenary power of superintendent's direction of control of preparation of electoral rules for conduct an election to Parliament and legislature of every state, hereby direct that the aforementioned person whose names have been provisionally entered in the electoral rules in the state of Assam and against whose name the letter D has been indicated to denote that his citizenship status is doubtful, disputed, shall not be allowed to cast a vote at the ensuing general election to the House of the People, and also at the election held thereafter, either to the House of People or to the Legislative Assembly or State of Assam or the Legislative Assembly, so long as the citizenship status of any such person is determined in his favor by the appropriate tribunal to whom his case has been referred. Now, my submission was, my lord, obviously this my lord, rules has given more details. And after the decision by the tribunal, after the opinion by the tribunal, it is the Election Commission who will, my lord, complete this, my lord, who will delete his name permanently if he is not a citizen of India. So the act, the section 2 of the Foreigners Tribunals Order 1964, it says, my lord, the central government may by order refer the question to whether the person is a foreigner or not within the meaning of the Foreigners Act 1946 to the tribunal to constitute for the purpose for its opinion. It's only for the opinion. It is, my lord, the opinion is part of the investigation, part of the inquiry. The inquiry was initiated by electoral registration officer. After an inquiry, my lord, after local verification, it is sent to the, my lord, Foreigners Tribunal for further opinion. And if the opinion is against the petitioner, then he will confirm it. If it is in favor of the petitioner, my lord, then his name will be confirmed in the electoral rules. So it is not, my lord, my submission is that the entire process itself covers the section 2. It is part, the entire process is under part, my lord, section 2 of this rule 2 of the 1964 rules. So the tribunals cannot be, my lord, segregated. The functions of the, my lord, powers conferred by, say, rule 2 of the Foreigners Tribunal Order 1964.
Now, what do you want to say? That the investigation doesn't stop on the reference made by the competent authority on the forwarding of the concerned officer, whether it is the police inquiry or it is the
Yes.
ERO. But that investigation continues up to the tribunal level.
Up to the tribunal is this. It's a continuous process, my lord. It will end once that opinion is given and opinion is returned back. Then it is the competent authority, that is me SP concerned, who may accept it, may not accept it also. The tribunal may accept it. My lord, it is an opinion. It is not a judgment. That's why, my lord, it is said, the term itself is saying, the tribunal constituted for the purpose for its opinion. I can seek opinion from anyone, my lord. I may seek an opinion. That's why in some cases we argued, my lord, in adjudicata. If we are not satisfied with his opinion, we may take opinion of another person also. Everyone may take opinion of different persons, my lord. So opinion is not binding on the state. Opinion is not binding on the, my lord, the SP concerned. SP has asked for an opinion. It's a process. Process was, my lord, in case of police case registered by the police. Police has initiated the case. Case is referred to the tribunal. Tribunal, after getting, my lord, all examining all documents and evidence, tribunal referred, my lord, give an opinion. Yes, he is a citizen or he is a foreigner. That will be referred back to the, my lord, sent back to the, my lord, SP concerned. SP may consider it, after may not consider it also, or may not, my lord, accept it also.
Yes,
That is not bound. That is not bound. So it is not, my lord, that the tribunal, my submission is the entire process, beginning from SP to, my lord, Foreigners Tribunal, again coming back to SP. It's an inquiry process. The entire process is inquiry process. The only the tribunal process, the process in the tribunal is not different from the inquiry process. It is part of the inquiry itself. So in an inquiry, in different states, there may be some different inquiry may that this part of the inquiry is wrong, this part of the inquiry is right. This that cannot be said. It's a full inquiry process, man. It's a process.
Okay. Then
That's why, my lord, the second thing, my lord, 64 rules is clear. I have already said, argued, my lord, 64 rule is clear that prior to giving reference to the even then, my lord, prior to giving reference to the tribunal also, there is no need of any inquiry. That is clear. And the Sobananda Sonowal has said, my lord, clearly said that those matters which has been transferred or which were not decided by the, my lord, even those matters which were decided earlier by the IMDT tribunal, those could also be referred to the tribunals, foreigners tribunal, by the SP concerned. So in the IMDT Act, there was a provision of inquiry that was followed in the earlier proceedings, and those have by this 2005 order, judgment of the Honorable Apex Court, those has been set aside. Now the entire process has to be followed. Process has to be followed on the basis of this 1946 Act only. The order Section 9 and Section 2 and Section 3 and Section 2 of the Foreigners Tribunal Order 1964. Tribunal, my lord, you also will find 84, para 84 of the Sobananda Sonowal. It has given details, my lord. In view of the discussion, my lord, writ petition succeeded and allowed the provision of IMDT set aside. Number 2, the tribunals of appellate tribunal. Tribunals at the appellate tribunals constituted under the Act 1983 says to function. All cases pending before the tribunals under the Illegal Migrants Determination of Tribunals Act 1983 shall stand transferred to the tribunals constituted under the Foreigners Act 1964 and shall decided in the manner provided in Foreigners Act, the rules made thereunder, and the procedure prescribed under Foreigners Tribunal Order 1964. It will be open to the authorities to initiate, that means the central government, my lord, to initiate fresh proceedings under the Foreigners Act against all such persons whose cases were not referred to the tribunal by the competent authority, whether on account of the recommendation of the screening committee or any other reason whatsoever. Those against whom doubts were there, their cases could be referred by the central government again without, but even though those were stopped by the screening committee or due to some other reasons, those were not referred. An appeal all appeal pending before the appellate tribunal shall be deemed to have abated. The respondents are directed to constitute official numbers of tribunal under the Foreigners Tribunal Order 1964 to effectively deal with the cases of foreigners who have illegally come from Bangladesh or are illegally residing in Assam. So, my lord, the facts, other aspects, my lord, the merits of the case apart from these 2 points, my lord, what is there in the merit? And as your lord, my learned senior friend has today morning, my lord, deferred the, my lord, this judgment of the Honorable Apex Court. It has clearly said, if there is no error apparent on the face of the record, that is the point for my lord, then it may not be interfered by this mandate. The finding of the tribunal on fact may not interfere, even though how my lord, it is grave in nature. That is the my lord, language used by the Honorable Apex Court. So we cannot reappreciate the evidence, my lord. Second thing, we cannot, my lord, question the findings of the tribunal. Whether the tribunal has committed, my lord, has accepted any inadmissible evidence or tribunal has not considered any admissible evidence, not considered any admissible evidence. That has to be seen on.
Kindly explain two things further.
Let me can we see. Pardon, my lord. Publish. Cannot do GMB reference. GMB. What evidence? Not enough. My lord, it is admitted position that the parents of the petitioner have no documents of any kind prior to 1971. There is no documents at all. That is admitted position. They have annexed the voter list of 66 and 70, those in the name of DW2, the projected brother. And thereafter, 85 voter list and certificate of Gaon Panchayat secretary that was not proved. Village hetman certificate was also not proved. The now remains the evidence of my lord, DW2 alone. Oral evidence of DW2.
Explain para 57 of the Central Council case.
There are 57.
First, read it and explain.
Yes. This is my lord, para 57 in Surya Dev Rai versus
The
Ramchandra.
paragraph prior to that.
Yes, then my lord, the judgment.
Thereafter.
Yes,
Thereafter. Next paragraph. After Surya Dev's case.
from aforesaid. My lord.
Hmm.
From the aforesaid, it could be said in terms of jurisdictional error that want of jurisdiction may arise from the nature of this subject matter, so that inferior court or the tribunal might not have authority to enter on the inquiry. It may also arise from the absence of some essential preliminary jurisdictional fact, where the jurisdiction of writs of certiorari, jurisdictional
body.
where the jurisdiction of body depends upon a preliminary findings of fact in proceeding for a writ of certiorari, the court may determine whether or not that finding of fact is correct. The reason is that the wrongly deciding such a fact, the court or the tribunal cannot give its jurisdiction. Well, this is jurisdictional fact.
No, that's what I say.
Yes,
What Mr. Dasgupta has pointed out before.
yes,
That the inquiry. No, normally the tribunal will not, the read court will not enter into the fact,
facts.
but when the inquiry itself is not proper or wrong, in that circumstances, the read court may determine. That's how he, Mr. Dasgupta has
My lord,
broke that paragraph part
may
by
read,
part.
may read it once
That's why we
again.
ask you to read that paragraph
Yes,
and
yes.
explain.
From the aforesaid, my lord, we have to read the aforesaid part also. it could be said in terms of jurisdictional error that want of jurisdiction, that want of jurisdiction may arise from the nature of the subject matter. The nature of the subject matter, my lord,
That's right. That's
Yes.
very good. So that-
nature of the subject matter, so that the inferior court or the tribunal might not have the authority to enter into on the inquiry.
Mm.
What is the nature of the subject matter is, my lord? The inferior court or the tribunal might not have authority to enter into the inquiry. The tribunal may not have entered into any inquiry, my lord,
Then,
because the subject matter, in fact, my lord, the subject here given to us, it is, my lord, whether the petitioner is a citizen or not,
the foreigner.
foreigner or not. That, my lord, authority, that jurisdiction has given by Rule 2,
Read the next part.
Rule
of
2 of the, my
read
lord,
the next part
order
of
itself.
that paragraph.
It may also arise from the absence of some essential preliminary jurisdiction, preliminary or jurisdictional fact. But what is jurisdictional fact, my lord? That has to be seen. Then, whether jurisdiction of the body depends upon a preliminary finding of fact. Jurisdiction of the body depends upon a preliminary finding of the fact in a proceeding for a writ of certiorari. The court may determine whether or not that finding of the fact is correct. So the court can determine, my lord, definitely this honorable court can determine whether the jurisdictional, my lord, fact where the jurisdiction of the body depends upon the preliminary findings of the fact. My lord, the question of preliminary, that's why I submitted, my lord. Question of preliminary findings.
The tribunal will have the jurisdiction
Yes,
as per Mr. Dasgupta.
yes.
That during the inquiry, a person is found to be
My lord,
doubtful.
What I understood, my lord.
So that's how the tribunal will first get the jurisdiction
Yes,
on being referred by the competent authority
competent authority.
to proceed with the case.
Yes,
What Mr. Dasgupta said, that since
those
the
materials were
inquiry-
not considered.
was not proper, it was
Yes.
not,
Those
it has been
materials were not
wrongly
considered
referred.
while
The
before issuing
tribunal-
notice, my lord.
the tribunal at the first instance itself should not have initiated or issued the notice because the inquiry is not proper. So he gets the jurisdiction only because of the inquiry process.
That's true, my
Finding
lord.
that person did not give any material. So whether
And
he
that's
is
why
or
I
she-
submitted, my lord, both this point. First of all, my lord, the present case, as I have already submitted, what the tribunal has considered. Tribunal prior to issuing the notice have considered, my lord, the ERO's report, ERO's report,
First of all, his-
A, B, and the reference from the SP. These three other documents before him. My lord, LVO could not collect any documents, as I have indicated, my lord. There are 14 kinds of documents which could have collected by the NBO. Those had to be submitted before the ERO. ERO could have sent all those documents while sending the matter before the tribunal, to the tribunal. Now, what materials were there before the tribunal while issuing the notice, my lord? These three documents, first of all, ERO's report, second, the LVO report, ERO's reference, LVO's report, and the police report. My lord, from the LVO report, it is clear the petitioner has not submitted any documents before the LVO. ERO has clearly, my lord, given the fact, given this, my lord, said in his notice that I have doubt as per section 2 and section, my lord, rule 2 of the Foreigners Tribunals Order 1964. If ERO has the doubt, he can refer the matter to the, my lord, Foreigners Tribunal. So ERO has said, my lord, after going through the reports of the LVO, I could not satisfy myself. So matter is referred to the Foreigners Tribunal for an opinion. Now, these three other documents, and on the basis of this, the tribunal has, my lord, no other option, because, my lord, the LVO has not produced. Had there been any documents produced before the LVO by the petitioner, that was the stage where the petitioner could produce his documents before issuing notice, my lord. Before issuing notice, he had the opportunity before there the LVO, but he did not produce any documents before the LVO. So the tribunal has, my lord, got the jurisdiction from the, my lord, report of the ERO and of the SP. SP has said on the basis of ERO's report, I have sent this matter as there is a doubt. We need an opinion whether he is a citizen of India.
Okay.
That is one aspect of the matter, madam. Second, what I'm saying, again, I'm submitting the second part. My submission is that but tribunal got the jurisdiction, even though tribunal got the jurisdiction that, in fact, that is, tribunal is not a separate entity, separate, it's cannot be separated from the entire proceeding. It's a part of the proceeding. The process of tribunal is a part of the proceeding of the inquiry, whether he is a citizen of India or not.
No, that's what Okay, yeah. Yes, Mr. Pine, anything else you'd like to add?
Not only 2 points, your lordship, one judgment of this Honorable Court. There is, my lord, distinction, my lord, there is this judgment has distinguished, my lord, the cases of two different kinds, debuter and the cases coming from police.
One is police inquiry, one is
Yes.
the ERO's reference.
Your lordship, there one thing, just I like to point out one paragraph. That was judgment of this Honorable Court in a single bench, but that was appeal.
Appeal was upheld, I think,
appeal was
upheld by
upheld.
division.
The lordship will find WPC 91 of 2019, madam. Yes, 2019. Well, just I like to read out two para, my lord. Para
Decided
20
when?
This was decided on, my lord, 1902-2019. Because, my lord, in this Muslim mandal, this has not been differentiated. There are two kind of references.
No, see, basically, the Muslim bundle is a case where it was referred to the full bench.
Full back.
Because there is a single judge judgment, then followed by a division bench judgment.
Yes,
And thereafter, the matter went to the
Full
full bench to decide that issue. So
Yes,
their lordships did not discuss the background of the case,
yes, ma'am.
from where it has been initiated.
Yes.
But if you read the judgment, you can understand that it's a matter from the coming up from the police inquiry.
Police report. Now, para 21 and 22, my lord. Para 21 says, my lord. Thus, from the above, which transpires is that there are two categories of D-voters. In fact, D-voters also two categories. Those who were marked as D-voters in the electoral roll by the electoral registration officer, inquiry by local verification officer, and those where reference are pending before the foreigners tribunal. My lord, those against references pending against them also there were D-voters.
Definitely.
Yes.
Even if there is a police inquiry and the matter
Yes.
has been referred to the
Foreigners
tribunal, then
If it is pending, it will come.
as a default.
There. Now, insofar as electoral registration officer is concerned, the exercise undertaken by him while marking as person as D-voter in the electoral rules is a quasi-judicial exercise. Electoral registration officer. It has holds the view after examining the inquiry report of the local verification officer that the concerned person is not a citizen of India, is required to forward the case of the person to competent authority, that is the superintendent of police. My lord, the ERO, the process before the ERO, before making reference to the tribunal, is a quasi-judicial process. It is the ERO being the quasi-judicial authority. He has taken an opinion. My lord, your lordship will find in the Annexure A, there is an opinion of the ERO, prima facie that he has doubt against that person that he is not a citizen. That's why reference is made to the tribunal. So from that, my lord, the tribunal got the jurisdiction. My lord, examining the inquiry report of the local verification officer that the concerned person is not a citizen of India, is required to forward the case to the person to the competent authority, that is the superintendent of police. If it is so forwarded by the electoral registration officer, the jurisdiction superintendent of police has to make reference to the competent authority, competent foreigners tribunal under the order 2-1 of the foreigners tribunal's order 1964, based on the report received from the electoral registration officer. The basis is electoral registration officer's report. Question of making further inquiry by the superintendent of police in such case would not arise because the inquiry has already been made by the electoral registration officer by exercising quasi-judicial powers, and the superintendent of police cannot sit over such decision of the electoral registration officer. So further inquiry by the police is not necessary in that case. He has to forward the same by making the reference to the competent foreigners tribunal for its opinion. That is the point to be noted, because the electoral registration officer, before my lord, as your lordship has seen in the form A, it is details has been given how the inquiry was conducted prior to making the reference to the foreigners tribunal. The inquiry was first, there was house to house enumeration. Then his name was appearing suddenly in the voter list of 1997. As your lordship has, I read out in the guideline, but it is said when his name was appearing without linking any father or grandfather, then there is a doubt created in the mind of the tribunal, the electoral registration officer. Then he makes a verification by the local verification officer, who is not a part of the election office. It is not a part of the election office. It is hired from the government. If the electoral registration officer gets a report from the LVO and satisfied that yes, LVO could collect some documents to show that yes, he is a citizen of India, he will allow his name to continue in the voter list of 1997. So this is an inquiry process. Before referring, my lord, this process was conducted. And this process was challenged before this honorable court. That has been upheld. That has been upheld by this honorable court in Isra Sudhir case. So there is no question on that, my lord. That is wrong. The process is wrong. Cannot be any question, my lord. So on that basis, that is the, my lord, point. That is on the basis of that only the tribunal got the jurisdiction. And further inquiry, as it is a quasi-judicial authority, my lord, the SP is a executive authority. So he cannot make further inquiry if a quasi-judicial authority gives us some opinion.
Okay.
So that point has to be seen. Another point on, even though that is, my lord, that is in case of police case, it is in case of police case, my lord, whether the police 3 points were raised in that writ petition, my lord, batch of writ petition. Sarifa Begum versus Union of India. There were numbers of writ petition, my lord. These points were raised by these numbers of cases. The leading case is 4989/2016, my lord.
Decided on?
Decided on 8/3/2018. There are the 3 questions were, my lord, raised.
8/3/2013.
18, my lord. 8/3/2018. WPC 4989/2016. And there were 6 numbers of cases, 7 numbers of cases.
Yes.
There in para 5, my lord, it is said what were the questions raised in those questions, my lord, writ petitions. Number 1, therefore, in the light of the submission made above, questions of considerations are: number 1, whether the police has power to make inquiry, investigation, and examination into the nationality of a person. Number 1. Number 2, whether any procedure is laid down under any statutes conferring and regulating the power of police to make such inquiry, investigation, and examination. Number 3, if so, or if no, whether in the absence thereof, the reference made by the police to the foreigners tribunal would stand vitiated. That is the point, my lord, we have to see. Whether in fact, this is a question of police reference, my lord. If the police make a reference, my lord, if the police had not made any inquiry, whether it will vitiate the proceeding or not. That was the point. There are the numbers of judgments of this were discussed. The notification of the central government has also been discussed. After discussing, my lord, para 20, the finding is there. Para 20, I'll read it out, my lord. A careful perusal of the above decisions of full bench, that is Sabananda Sunwal, would go to show that before making a reference to the foreigners tribunal, an inquiry is made by the police as to nationality of a person concerned. Since it may not be possible and feasible for the superintendent of police to individually supervise the inquiry, the same is carried out by the subordinate police officials as an inquiry officer. At this stage, we may also note, having regard to the peculiar problem of inflation of foreign nationals into the state of Assam, the state has created a special wing in the Assam police called Border Police to deal with the problem of illegal migrants. Personnel belonging to border wings of Assam police carry out the inquiry and therefore submit report to the superintendent of police, who is the referral authority. How the inquiry is to be carried out by the officer has been detailed in para 97 of the Muslim Mandal. While laying down the guideline, the full bench clarified that such investigation need not be detailed or an exhaustive one, keeping in view of the nature of the proceeding before the tribunal and objects sought to be assessed. My lord, after police inquiry, there is a full process in the tribunal. So seeing the nature of the tribunal, my lord, it is said it may not be detailed, the inquiry before the police. It was further clarified that such inquiry or investigation need not be equated to an investigation conducted in criminal case. Therefore, broad framework of the inquiry to be conducted by the inquiry officer has to be laid down in Muslim Mandal. That apart, inquiries report submitted by inquiry officer following inquiry is not final. It is not final, my lord. As held in paragraph 98 of the materials collected, as held in paragraph 98, the materials collected by the inquiry officers are required to be gone into by the referral authority before making the reference. While holding the reference by the referral authority cannot be mechanical, and that he is to apply his mind to the materials collected by the inquiry officer. It has, however, been clarified that no detailed order recording satisfaction is required to be passed by the referral authority. An order agreeing with the investigation would suffice. It is thereafter the referral authority make the reference, which is accompanied by the materials collected during the inquiry, including the inquiry report. If the foreigners tribunal is prima facie satisfied, this part has to be seen. If the foreigner tribunal is prima facie satisfied on the basis of the materials on record, then it should issue the notice to the proceeding. Well, it is prima facie satisfaction of the tribunal.
Yes.
So the prima facie is that the ERO has not cast doubt. His name was the LVO could not submit any documents. The petitioner could not submit any documents before the LVO while he was inquired. These are the prima facie on the basis of who is the tribunal has issued notice against the petitioner. Okay. One thing we have to as section 9 says, it is the burden of the petitioner to prove that he is not a citizen of India. So here, the prima facie satisfaction of the petition of the tribunal that he is not a citizen of India, that is the report of the ERO. And the petitioner has to show that he is not a foreigner by adducing evidence. In absence of documents, in absence of any materials to show that he is a citizen of India, the tribunal has no other alternative but to issue notice against him. The prima facie satisfaction he will get that from in absence of any records of his Indian citizenship, it is the prima facie satisfaction of the tribunal that yes, a notice can be issued against him or her to show that he is a citizen of India. That's all. And apart from otherwise, my lord, on the basis of the oral evidence, I'd like to point out to judgment of this court that oral evidence itself is not enough. Those, my lord, because the petitioner could not see. My lord, I'd like to point out to judgment with this Asia Khatun 4020/2017.
4020.
Yes, my lord. 4020/2017 and 1900 of two judgments, my lord, and 1900 of 2019. One nine double zero 2019. Asia Khatun. Nur Begum. Nur Begum. There it is said, my lord, the statement of DW2 at para 6, my lord, who claim to be mother of the petitioner cannot be relied upon in the absence of any document showing her relationship either to the projected grandfather, father, or to the petitioner herself. In the present case, my lord, the DW2 has come before the tribunal and deposed that she is my sister, but there is no document to show that she is her sister.
No.
That's why the tribunal has, my lord, neither he has shown any link to his projected father or grandfather, any documents to show that he is the son of so-and-so, grandson of so-and-so. So in absence of those documents, his oral evidence is not enough to establish a citizenship of the person.
Okay.
That is on the point of, my lord, oral evidence of DW. Others, I leave to you, lord.
Yes, do you want to suffice anything? Do you want to suffice anything?
No, so only one point that what Blendier transpires, that the tribunal was of the opinion that the election officer made an opinion that he is a foreigner. And for that reason, the notice was issued. That is the sole contention, as I have understood. And he wanted to say, my friend Leonard wanted to say that the election officer is a quasi-judicial officer, quasi-judicial authority, and the superintendent of police is an executive authority. So superintendent of police is not supposed to examine whether his report is correct or not. He is to send it to the tribunal for his correction. That is what is long submission. It transpires in that. So let us know, all right, accept his opinion. Now, if we go to the material on record, there your lordship will find that the election officer had no occasion to give an opinion to the effect that he is a foreigner. So had there been so, then I would have accepted. Yeah, all the election officer has given it, then I am casting doubt on her. He simply went there and submitted his report. He simply went there and submitted his report to the superintendent of police. And superintendent of police mechanically transmitted the matter to the tribunal for its adjudication. Now, as per Muslim Mandal case, and that was delivered in the year 2013, and now the Supreme Court delivered the judgment in 2023. It is very surprising that the judgment of this High Court, which was delivered in the year 2013, I am conducting so many cases of the against the tribunal, but nowhere I have found this type of judgment. This is a very landmark judgment, what I should say. Now, tribunal has issued this notice on the basis of the, let me assume that his submission is 100% correct, that the tribunal has issued the notice on the basis of the election officer's opinion. But is there any opinion in this regard? No opinion is there.
Okay.
Now, second thing, what my learned friend wanted to say, let me go against me. What learned friend wanted to say, that when the election officer went to the proceeding and he demanded certain documents, as she could not produce this document, it should be presumed that he is a foreigner. It is his submission. What is that? To that effect, there should have a finding or something to say that yes, I cast some doubt. That is one aspect of this case, Milord. And Milord, so far the other aspect of this case, so far the perversity as well as the non-acceptance of the admissible evidence, or whether this is such a judgment where a reasonable person who is minimum instructed by law will assert these findings or not, that I leave it to your lordship, Lord.
No.
I'm sorry, that you have troubled your lord.
No. This law issues are interesting for us and we'll also decide.
Well, you're genius, really. I am greatly obliged to your lordship because your lordship has pointed out to this judgment.
My lord, only.
Though this judgment was delivered in the year 2013, but not in that way. That which is really very good judgment.
My lord, may kindly on this, note the para page 34. That is the EROs, my lord.
We have seen.
Yes.
We have read.
So I just wanted to point out that.
We have already pointed out.
Yes. 34 and 33.
Okay. Heard. Mr. Ida Sukal and senior counsel for the petitioner, assisted by MS Vidas, learned counsel for the petitioner.
On item
We
number
have
19.
also heard Mr. J. Pang, standing counsel from Department Assam, for the response number 2. 6. Mr. H. Cooley, standing counsel, Election Commission of India, for the response number 3. And Mr. H. K. Hazarika, learned Government Advocate Assam, for the response number 5. Where is the records in original? Relating to paragraph, huh? FT case number 408/2015 on the Learned Foreigners Tribunal, 9th Borpeta, wherein the said tribunal by the impugned judgment and order dated 28/05/2018 who find the petitioner to be a foreigner under the Foreigners Act 1946. Of post 1971 stream. Who had illegally entered the territory of India in Assam from the specified territory of Bangladesh. Arguments are heard. Order is up.
Item number 19. Yeah?
Call for the record. We have also called for the record. It's okay.
Well, I have another item number 19.
Huh.
May I be excused for that item, Lord, today?
Next week
Any date, your lordship.
on 11th,
Any date, your lordship. I want to get rid of all those cases.
after a week. On the prayer of Mr.
Please, Your Honor. Well, this matter relates to the you have declared under stream 6671. I have already registered also under the provision, and it is almost 10 years going on, 9 years, some months, my lord. That we have challenged the judgment on the fact that my father came over India with the migration from the Gulf of India from Dhaka. And when we arrived at Tejpur, we have given shelter in a refugee camp. And we have been given a rehabilitation loan in 1968 by executing a bond.
Whether your name was there in the chart,
Yes, everything was there.
your name was there in the rehabilitation chart
Yes, madam.
or in that particular document where it was.
Relief certificate, your Lordship, my father's name is there. And in fact, my Lord Pradeep
How you
Chandra,
have proved your link with your father?
beg your pardon?
How you have proved your link with your father?
No, that has been admitted in that opinion.
Then why
Only
did,
that the opinion has given that I am a foreigner under the stream of 68.
on what
67.
basis? That is what we want.
My Lord, kindly peruse the judgment, opinion, page, annexure 6, my Lord, kindly. This reference was forwarded by the Superintendent of Police SP Fraud, Shunitpur, Tejpur to Learned Member Foreigners Tribunal, Tejpur, Shunitpur, Assam for trial of foreigner national for deletion from voter list of the 10 years, for 10 years by letter dated 21/9/2002, White Memon Masajay. In the said letter, it is specifically mentioned that an inquiry report together with the interrogation report was submitted by the inquiry officer against the proceeding who entered into India during 66-71 with a request for necessary trial of the proceeding thereof. The learned members Foreigners Tribunal by order dated 10/9/2004 has declared ex parte that the proceeding was a foreigner within the stream of 1166-25-371. Thereafter, the proceeding approached the Honorable Guwahati High Court by filing a writ petition, and Honorable High Court by order dated 11/5/6 set aside the ex parte order and directing the proceeding to appear before the learned tribunal on 26/6/2006, enabling him to defend his case by adducing evidence. But the proceeding could not appear before the tribunal due to serious illness of his minor son, and thereafter he was busy in cremation and funeral program after the death of his minor son. The proceeding thereafter filed another petition by WBC number 5687/2015, wherein the Honorable High Court order dated 13/11/15 directed the proceeding to appear before the tribunal on or before 30/11/2015. Thus, the proceeding appeared before the said Foreigners Tribunal, first at Tejpur, and the said learned tribunal by later dated 30/11/15, White Sasan has transferred an aforesaid reference to the tribunal on the ground of jurisdiction. The proceeding has filed a petition on 11/12/15, White Sasan, and the tribunal has returned the aforesaid reference as FT for Sasan by preparing a dummy file for disposal. Along with this petition, as aforesaid proceeding also submitted a copy of the Honorable Guwahati High Court order dated 11/5/2006, passed in WBC number 1983/2005, and White order dated 13/11/2005, passed in WBC number Sasan before this tribunal. This tribunal, after due consideration of the fact that the ex parte order dated 10/5/2004 has since been quashed by the Honorable High Court in terms of the order dated 11/5/2006, and also compliance of the order dated 13/11/2015, passed in WBC number 5687/2015 by the proceeding, directed the proceeding to file the written statement with documents on or before the next day fixed. It is also directed that the proceeding is required to execute proper bail bond, keeping in view that the fact that the reference has been pending since 2002, thereby fixing the matter 22/12/2015 for WS and documents of the proceeding. The proceeding filed the written statement, WS for short, the 22/12/15, and also executed bail bond through bailer Srimati Shefali Das, and accordingly the proceeding was allowed to go on bail. The proceeding claimed that he is an Indian citizen by birth. Thereafter, the proceeding has filed the evidence on affidavit, hereinafter called the affidavit, along with his documents relied upon by him in support of his version. Now, the point for determination is also as to whether the proceeding is a citizen of India or a foreigner within the meaning of the expression foreigner as defined in Foreigners Act 1946. I have gone through the WS and the evidence on affidavit filed by the proceeding as well as the documentary evidence on records very carefully. In the written statement filed with the instance of the proceeding, it is pleaded that the father of the proceeding, namely Sri Banko Bahar Bihari Chando came to India in the year 1964 from East Pakistan, now Bangladesh, due to communal riot. There, at that time, he used to stay in the rehabilitation center at Panchmail, Tejpur. There, the Government of Assam allotted a portion of land measuring 6 bighas in the name of the proceedings father at village Sakura, PS Gohapur district, Sunitpur, Assam, by executing a bond at Tejpur sub-registry office in the year 1968, dated 23/2068. The proceeding also included the fact that the proceeding casted his vote for the election of number Gohapur Constituency Assembly, and his name was enlisted in the year voter list of 1985 for the state constituency assembly in respect of the village Sakura against the serial number such and such. Thereafter, the proceeding has filed evidence on affidavit and duly exhibited the certified copy of the electoral roll of Gohapur and constituency and section 3 of Sakura pertaining to such and such 1185 in qualifying date is proceeding as exhibit 1 land documents of his father relating to the rehabilitation scheme. Exhibit 2 is the certificate from the Government of Gampura. The exhibit 3, the certificate issued by the Panchayat. Exhibit 4, school certificate. Exhibit 6, recent land revenue paying receipt as exhibit 6. On being queried, the proceeding has replied that he has not submitted any document showing the name of his family members prior to 68 and born of 1968, also did not disclose the name of his family members. He also stated that he did not know whether his father or his family members have casted their vote in prior to 71. The proceeding also submitted the evidence of Sri Joy Chandra Dutt, who stated in his affidavit that the proceeding was born on 2 Sakura village under Gohapur police station. The said witness also said that he knows the father of the proceeding, late Banko Bahadur Bihari Chanda, very well, and late Bharat Chanda is his father, late Banko Bihari Chanda. The proceedings witness Sri Joy Chandra Dutt's father of the said late Banko Bihari Chanda came to India on 6/4/1964 along with his thereafter, and were issued migrants family card at the rehabilitation camp Tejpur. Thereafter, the Government of Assam allotted 6 bighas of land to them, including Banko Bihari Chanda in the year 1968. The instant evidence also reveals that the fact that the father of the proceeding died in the year 1972 at Sakura, etc. Proceeding also examined the Government of Gampura, namely Dhoniram Neok, son of such and such. In his affidavit also, he knows that proceeding very well, and he also knows that father of the proceeding, late Banko Bihari Chanda, who came to India on 6/4/1964, and after staying in the rehabilitation camp at Tejpur for 4 years, the Government of Assam allotted 6 bighas of land in the year 1968. He further deposed that the late Banko Bihari Chanda died in the year 1972 at 2 number Sakura Gaon. One Sri Subhash Sarkar, who is the BDP secretary of the 2 village Sakura, also filed evidence on behalf of the proceeding and said that the father of this proceeding came to India in 1964 and Government of Assam allotted 6 bighas of land at Sakura. On perusal of the WS affidavit filed by the proceeding as well as the documents relied upon the same, it is found that although the material exhibits starting from exhibit 1 to exhibit 6 are exhibited but not proved in accordance with the evidence of Act, the exhibit number 2, that is the bond executed by the state of Assam 68 in favor of the Banko Bihari Chanda for allotment of the land measuring 6 bighas in 1968, has been substantiated by the evidence of Sri Anil Das, who also claimed to have received similar benefits from the state, and corresponding evidence of Sri Joy Chandra Das, Gop Gampura, and VDB secretary also complemented the said fact that which propelled this tribunal to believe the existence of the family of the proceeding in the year 1968. Although all the witnesses, including the proceeding, factify that the proceeding's father came to India in 1964, but no documentary evidence, including the migrant family card, could be submitted by the proceeding to authenticate the said fact. The proceeding also could not prove the substantiate the fact that his family members, including lineal ancestors, have casted their vote in 1956 or existed in the Indian territory before 1966. The exhibit number 1, that is the certified copy of the electoral rolls of 1970 Gohapur constituency section 3, Sakura village, pertaining to 1/1/1985 as qualifying date for proceeding, clearly shows that on 1/1/1985 as the qualifying date for voting for the proceeding. the land revenue being received of 27,670, and the current revenue receipt, that is 8, Exhibit 6 also depicted that the fact that the land documents confirm the existence of the government allotted land only in 1968. In this 10 case, the proceeding has failed to submit any document which substantiated his fact of the existence of his family prior to 1968. In this periphery of the matter, it is incumbent upon this tribunal to discuss section 6A3 of the Citizenship Act, which specifically said that the persons of Indian origin who came to Assam on or after 1st day of the January 1960, but before 25 day of March 71, from the specified territory, hence been the date of his entry in Assam, has also been ordinarily resident in the Assam, are to be detected as a foreigner who have to be registered in his name within the registering authority, and if his name is included in the electoral rolls of the Assembly of Parliamentary Election in the force on the day such election name shall be deleted therefrom, etc. The Honorable High Court, Muslim Mandal versus reported in 2013, GLT Sajid. The evidence adduced at this instance of proceeding, coupled with the above mentioned documents relied upon by him, appears to be not trustworthy, and there is nothing on record to believe the proceeding so as to it relates to the existence of the family of the proceeding 1968. I found the sufficient proof on record to come to the definite conclusion that the parents of the proceeding entered into the territory of India on 1/1/1968. It is also established that the proceeding is born and brought up through genuine Indian parents, and as such, he is not the descendant of the Indian parents in the Indian soil, and he failed to prove that he is not a foreigner. Considering the entire material on record and the discussion above, I am of the considered opinion that the proceeding Sri Pradeep Chanda, that is the petitioner before your Lordship, is a foreigner, illegal migrant, and his family entered into territory of India between 1/166 to 71, and he is required to be registered before the requiring authority within the period of 30 days from the day of the order dated 6C of Citizenship Act, Part 4 of the Citizenship Rules 2009. Hence, reference case is answered affirmative and against the proceeding. The bail bond of the executive is also discharged. Intimate the Superintendent of Police B. Vishwanath Charali accordingly also informed the learned Deputy Commissioner Sonitpur District release the name of the petitioner, named Pradeep Chanda, son of late Chanda, Sachin of village Gopur, Sonitpur, from military roads and this. Now, so after this, my lord, he had no other alternative. He registered his name before the authority, my lord. And accordingly, for last 10 years, he is debarred from voting. But from the judgment itself, my lord, what I submit, my lord, what I feel, and my limited knowledge, my lord, even the two independent witnesses has categorically stated that he was born in India. And the loan given by him to his father, my lord, by Government of Assam, land given by the Government of Assam, and they are staying in the refugee camp at Tejpur. All this indicates primarily that they are the bona fide displaced person from Pakistan, in not Bangladesh, my lord, in the 1964. And he ought not to have been declared a foreigner, my lord. That's why we have come, my lord, here before that. This order may be set aside and quashed, my lord, and I may with the direction that I may be declared the citizen of India.
Who proved the documents?
Beg your pardon?
Who proved the documents?
My lord, there are two independent witnesses also. They appeared before the tribunal. They said that he was born here. We know his father, his grandfather. School certificate, Gaumura came.
There is no evidence, only the evidence in affidavit.
Yes, my lord, that's it.
There is no evidence of the.
There was no suggestion from the government side, state side, my lord, that the Gaumura, that you are wrong.
It is the duty of the proceeding to prove that certificate to be proved by the proceeding.
My lord, even the land documents and the loan documents given by the Deputy Commissioner, it's a government,
Now,
public document, my
are you
lord.
aware that the tribunal have asked certain questions to the proceeding? The
Well,
court
it is
proceeding
not, in the not judgment, it is not reflected, right?
It is in the record, that's why I'm asking you.
But that is not known to me, my lord. And my lord, the loan documents given to me, the bond executed by the Deputy Commissioner, page 14, your lordship will find that is specifically meant that I am a displaced person of Pakistan and came to India in 1964.
In his evidence before the tribunal, the proceeding said, listen very carefully. I
I
have
hope,
not submitted any documents showing the name of the, should not be this, say of my family members prior to 1968. The bond of 1968 I submitted did not disclose the name of my family members.
it is not, only loan was granted to his father.
I do not know whether my father or my family members have casted vote prior to 1971.
Their name was not there. That is true.
Now,
Mayor not casting vote may not be declared a foreigner.
a voter list was placed before the tribunal,
Yes, that is 85, madam.
but the said voter list doesn't give any year, excepting the last line. The certified to be true extract from the electoral roll of the above mentioned constituency revised with reference to 01/01/1985.
Yes.
That much.
That is certified to be, my lord.
Understood?
Tribunal should have taken the
So, in the
consideration.
year 85, the procedure was 22. So, as per this, you are supposed to have born in the year 1963, right?
Yes.
Full certificate.
School certificate has been produced, my lord.
Full certificate was of 25th of November 1996.
Yes.
This document was not proved. It is okay, the national emblem. Now, it was said that it is of 1993, not of 96, 93. Pradip Chandra, Pita Sorgio Bonko Chandra.
Chandra.
It is not there. Bonko Chandra.
Chandra. That is title is Chandra, my lord.
Gaon 2 number Pokura,
Shukra, yes.
Thana Gahpur, Biswanath Mahkuma, Shonitpur Jilar, Pokura Refugee Prathomik Bidyalয়ত পঢ়িছিল। ইংৰাজী 1975 চনৰ জানুৱাৰী মাহৰ 31 তাৰিখত তেওঁ এই বিদ্যালয়ৰ প্ৰথম শ্ৰেণীত পঢ়ি আছিল। বিদ্যালয়ত থকা কালত তেওঁৰ স্বভাৱ চৰিত্ৰ ভাল আছিল। 1993 চনৰ 31 অক্টোবৰত 31 অক্টোবৰত তেওঁৰ বয়স ভৰ্তি বহী মতে 25 বছৰ 9 মাহ। So, born in the year 1968.
Yes.
Which documents you have proved?
Learned Tribunal has already discussed all these things, my lord, that I have exhibited exhibit 1, 2, 3, 4, 5, 6, 7, 6 documents. Document your father relating the rehabilitation scheme. Exhibit 1, land documents. And Exhibit 2 is the Assam's rehabilitating schemes and certificate of the Gambura. Gambura also came under Exhibit 3. The certificate issued by the Panchayat, Exhibit 4. Certificate issued Exhibit 5, the recent revenue receipt. Exhibit 6, this revenue paying revenue receipt. School certificate Exhibit 5. Madam.
Say he only knows.
VTB secretary in his evidence said that his father came to India in 1964 and allotted 6 bighas of land.
Mr. Pine, I haven't seen anything in records. Where from that order was written, God only knows.
I have registered my name on 1/4/2016, madam, under Foreigner Regional Registration Officer, Sonitpur, Tejpur. Exhibit 7, madam.
No, it's good. We can- you can- we can human money. Well.
Protection of the protection of the petition.
Mr. Biswas, take your seat. If you have. Corporate ground, village con, subdivision Gokul, থানা গহপুর জেলা খনিজ কোন গাঁৱত নাই আৰু ইয়াতে জলস্তৰ ইয়াতে কোনো এইখন গাঁৱৰ লগত কোনো সম্বন্ধ নাই 2 নম্বৰ চকুৰা গাঁৱৰ নেক্সট আৰু এখন আছে তাতে আছে অন্য WS atau personal atau publik jadi এইখনে আমি একসেপ্ট কৰিব লাগে he was not a person. He was not.
Written evidence of some persons have been filed, my lord. Written affidavit,
Written affidavit is there. Evidence in affidavits are there.
yes, but no cross
The documents have not been proved.
documents are not. DGP secretary came,
His statement is there.
I filed affidavit on it.
On that much. Then residing at Sokura, Moza, Gokul. Food. Gokul. Corogona, subdivision. Moza, Corogona, yes, Gokul. Yes, okay. So for the. Kindly read his written statement. I just read, you'll get it later portion, not in the first side of the records. Down below you'll get. You got it?
Yes.
That land document is the person, that lady who was a bailer to the petition.
Yes. Yes. Written statement of the opposite party, madam. It is most respectfully submitted by the opposite party as follows. That the present case initiated against the opposite party is not tenable in law, and hence the LS declaration of opposite party as foreigner by the declaration made in this tribunal by the superintendent of police Sonitpur is most illegal and is injurious and ultra-virus. The opposite party is a Indian citizen residing at village number 2 Sarkura, Post Office Gopur, Moja Gopur, PS Gopur in the district of Sonitpur, Assam, and born and brought up in the above mentioned locality, having both movable and immovable properties in his name. As such, the opposite party could not be treated as foreign national.
So he was born and brought up at village Sukura.
Yes, ma'am. Born and brought up in the above mentioned locality, having both movable and immovable properties. That the father of the opposite party, late Banka Bihari Sanda, was the original resident of village number 2 Sarkura, Post Office Gopur, Moja Gopur, PS Gopur in the district of Sonitpur, Assam. That the father of the opposite party had come to India in the year 1964 from East Pakistan, now Bangladesh, due to communal riot there at that time, and used to stay in rehabilitation center at Panchmile, Tezpur. Thereafter, the government of Assam allotted a portion of land measuring 6 bighas in the name of opposite party's father at village Sarkura, Moja Soincho, Assam, by executing a bond at Tezpur Sub-Registry Office by serial number Soincho in the year 1960, dated 20/03/1968. The opposite party, Pradeep Saha, had cast his valuable vote for the election of 78 Gopur Constituency Assembly, and his name was enlisted in the voter list for the year 1985 for Gopur Constituency Assembly in respect of village Sarkura against serial number so-and-so. The opposite party has got some relevant papers and documents which will ascertain that he is a bona fide citizen of India, and under no circumstances the opposite party could be treated as foreign national. The opposite party was born at village number 2 Sarkura, Post Office Gopur, Moja Gopur, PS Gopur, District Sonitpur, Assam, in the year 1968. That interestingly, though notice had been served by Honorable Tribunal upon the opposite party in connection with the above mentioned case, the opposite party has been casting his valuable vote in the electoral for 78 Gopur Constituency Assembly, and the name of the opposite party has been enlisted in the electoral roll for number 78 Gopur Legislative Assembly for the year 1985 in respect of village number 2 Sarkura, exit serial number so-and-so. The opposite party is an Indian citizen, have got sufficient valid documents to prove to international.
There is no mention, raised facts that he studied in particular school or not.
No man. That is not mentioned.
Nothing.
Now,
Accordingly. Tell us. I know what's her anyway. Almost 10 years, 10 years ago, we were. When enter into a legal battle, that all. We will think considerable. Genuine mano, whole family would do. This one, mano, go.
registration to government.
Oh, only 10 years actually. Like you, this is actually the whole year. There is a direction to register within 1 month. আমি যদি কোড লাইটে থেকে একটা রেজিস্ট্রেশন করলো রেজিস্টার
My lord, in the present case, my lord, where the petitioner has
just tell us the finding of the tribunal that the parents of the proceeding entered into the territory of India in between 1/1/1966 and 25/03/1971. Is correct or wrong?
But from the records available,
Hmm.
the petitioner is unable to produce any documents to show that the registration certificate. The bond is executed on 1968.
So there was no documents before the tribunal to show that the parents of the proceedee was in India prior to 1/1/1968. But for this purpose of uh, receiving the land
Yes,
under the provision of the settlement of this person, there is a particular act, 1951 act. So it's a kind of settlement. Whatever the income they will get, they will be able to manage. Right? And after a certain point of time, on paying of necessary amount, the land is given in the name of the settled with the name of the person concerned. Now, this land was allotted to the projected father of the proceeding with effect from 1968.
yes.
But no such documents could be shown by the proceedee to show that his projected father was available in India prior to that. Assuming that, that to get that benefit of settlement of land, the 1951 Act. So he has to be here prior to that, but it cannot be said that he was prior to 1/1/1966.
It is true, my lord. Citizenship. My lord, a person who is a foreign origin, even though he enters in India, after those who enters India after 51 or 48, they have to register themselves. But the citizenship cannot be acquired by that way, my lord. So once, if he is not a citizen, first of all, he has to be citizen, then only land can be granted to him.
No, that is why, see, what is the language of that? It is basically Assam Displaced Person Rehabilitation
Yes,
Loans Act. It's a loan, an amount. But since that, if you go to the that 1951 Act statement and reasons, you'll see the reason why it is given as a, instead of giving cash, it is given land so that he will cultivate over it and he will get the sufficient amount of money to manage his family by cultivation. That is the reason.
yes.
So loan was not given. At that point of time, there was sufficient land to consider to grant. So it was provided like that.
So whatever manner, my lord, it is, if this document is correct, the existence of the father of the petitioner is from 1968. So that is one aspect of the matter, my lord. And now, second thing is, whether the petitioner is able to establish himself to be son of this, my lord, Banka Bihari Sanda.
That at this stage now will be able to argue because there is no appeal from the state.
No,
He could not. Let us
Yes.
assume now can we, even if there is no such proof on the record by proving any such document or whatever,
yes, ma'am.
ultimately the tribunal has assumed that he is the son of Banke Bihari Sanda. But apparently there is no document before the tribunal to
Yes,
establish the fact that his projected father was here prior to
1968.
Okay. Okay, Assam relief certificate. He came to India on 25/4/64. As per the migration.
Have you proved that document before the tribunal?
Well, it is admitted by the opinion, my learned member merit. That the relief eligibility certificate merit. That is a public document. It has been signed by the relief officer of to Assam.
Which are the exhibits? Come to page number 42.
Exhibit 1.
Your 1985 voter list is exhibit 1.
Yes, sir.
Then rehabilitation scheme exhibit 2. That's land document you have given.
Yes.
Then the Gaambura certificate exhibit 3. And who that Gaambura belongs to which village?
Our same village,
See,
Sukura.
read it.
Sukura.
It is not there at all.
But it is mentioned in the opinion.
If you can read it, Sukura or he that look at the particular annexure.
He
you can
specifically
see that.
said that I know him and his father.
First of all, the Gaambura has to from the Sukura village. Where is that? Then exhibit 4 is the Panchayat certificate. Exhibit 5 is the school certificate. And the exhibit 6 is the land revenue paying certificate.
The agreement is not a part.
Hmm?
That agreement is not not exhibited.
The agreement is there, but photocopy is there. Page number 39, Sarkari Gaambura, which
Yes,
village?
sir. Yes, madam.
Where is Sakura? Since you have not reviewed that evidence, how come?
No, it is Gaura into Siddhabuyanai.
Under Dhoniram Neog, read it.
Nee, Dhoniram.
Gaambura,
Yes, yes.
then which village?
Mikir Bora Suk.
That is why we are asking you. It belongs
Probably
to-
Sukura comes under
Had
his
he been
jurisdiction,
to-
probably.
Had he been to a village, Sarkari Gaambura of Sukura village, it would have been the top itself. A very interesting kind of certificate. The village name is not there. Subdivision is there, police station is there, district is there, his phone number is there, but which village is not there.
Yes, Sukura নাকি itu?
Sukura to Sarita forward. Sukura.
খুব স্পষ্ট নয়।
Sukura Sarita forward.
But in his deposition, he might have said that. I mean,
Whatever, we do not know. Mr. Fine, give us the record.
yes.
No document, I took that they have. He's a resident of Mikir Borasu. উল্লেখিত ঠিকনাৰ স্থায়ী বাসিন্দা চকুৰৰ স্থায়ী বাসিন্দা এইখন গাঁও যে তেওঁ গাঁওবুঢ়া হয় সেইটোতো নহয় Mr. Payeng, there are 3 other witnesses
Yes, madam.
who have filed their evidence in affidavit. Now, see, 2 of the persons who have filed their evidence in affidavit. One is DW2 and DW3. Now, according to them, they along with the father of the proceedee came to India from Pakistan in the year 1964. According to them, they stayed in the house of in the rehabilitation center, rehabilitation camp at did not place Tezpur, and they obtained migrant family card. Nobody have adduced any such migrant family card.
Yes.
Now, according to them, after staying in the rehabilitation camp for 4 years, they have been settled with the land with 6 acres in the year 1968. That is the statement of DW3 in the written evidence
Yes.
in affidavit, as well as the DW2. DW2 and DW3 is the same affidavit. And both of them came from East Pakistan, along with the father of the proceedee. Same, but nobody have annexed anything. And there is no document to show by the petitioner that his father was in the rehabilitation camp at Tezpur since 1964. And document that has been annexed by the petitioner, whether it is proved or not proved, we are not going to that extent at this moment. It is not prior to on 1966. The land document is of 1968. Whether prove or not prove, we cannot go at this moment. Now, the village headman talking about, he is, I don't know where from he has given the certificate. You have seen that is annexed. There is,
Yes.
it doesn't show anything that he is the village headman of village Sokura. Now, in his evidence in affidavit, he said, উক্ত গোচৰ সংক্ৰান্তত 5 নম্বৰ সাক্ষীৰ শপত পত্ৰ what the others we do not know. মই শ্ৰী ধনীৰাম নেওগ পিতা ফণী নেওগ খাং ও ডাক মিকিৰ বৰাচুক থানা মৌজা গহপুৰ জিলা শোণিতপুৰ অসম ধৰ্ম শপত খাই ঘোষণা কৰোঁ যে মই উল্লেখিত ঠিকনাৰ স্থায়ী বাসিন্দা হওঁ. So he belongs to village Mikir Borasu. এই গোচৰৰ অপৰ পক্ষ শ্ৰী প্ৰদীপ চন্দ্ৰক মই চিনি পাওঁ, চন্দ্ৰাক চিনি পাওঁ, ভালদৰে চিনি পাওঁ, আৰু তেওঁৰ দেউতাকৰ নাম স্বৰ্গীয় বংক বিহাৰী চন্দাক মই ভালদৰে চিনি পাওঁ। বংক বিহাৰী চন্দাক দেউতাকৰ নাম ভাৰত চন্দ্ৰ, এই কথা সত্য। বংক বিহাৰী চন্দ্ৰ দেউতাক ভাৰত চন্দ্ৰ 6/4/1964 তাৰিখে ভাৰতলৈ আহিছিল আৰু তাৰ পাছত তেওঁলোকে তেজপুৰ ৰিহেবিলিটেশ্যন কেম্পত 4 বছৰ থকাৰ পাছত অসম চৰকাৰে গহপুৰ থানাৰ অন্তৰ্গত সকুৰা গাঁৱত 6 বিঘাকৈ মাটি আবণ্টন দিছিল। উক্ত মাটি 1968 চনত দিছিল, এই কথা সত্য। 1972 চনত অপৰপক্ষৰ দেউতাক বংক বিহাৰী চন্দ্ৰাৰ 2 নম্বৰ সকুৰা গাঁৱত মৃত্যু হয়। বৰ্তমান অপৰপক্ষ উক্ত উল্লেখিত গাঁৱতে বসবাস কৰি আছে, এই কথা সত্য। So he is not a resident of Sokura village, but he has seen, neither he is the village element of Sokura village. There is no statement to that extent.
That's why, my lord, apart from my lord, ignoring the my lord, other aspects, even though we accept the petitioner's father petitioner is the son of this Panko Bihari Sanda, and his residence resident in India, or his presence in India is shown only from 1968. But here, my learned senior friend has shown one documents, probably that was not executed before.
No,
the
it is
tribunal.
not. You see,
Yes.
the proceeding himself filed written evidence and affidavit,
Yes,
and
he has
also in his evidence, he
He
clearly
has not
stated,
stated about
he
this
did not
document.
state about this particular document,
That's why, my lord.
and his name is not there.
His name is not there.
It's not a part of the exhibits before the tribunal. So, Mr. Tanda, Biswas.
Yes, my lord.
You have seen. Had there been any such document of your projected father who did the rehabilitation come in 1964, it could have been
My
something.
lord, he was born in India, this person.
Mr. Sando, the petitioner might have born in India, but he is showing that he is client to his link document to his father. Where is that relief and rehabilitation camp center? He has taken.
My lord, two independent witness specifically said he is the son of
It
that.
doesn't matter without any document that cannot be considered, but the tribunal has considered it. That's not the law. That's not the law. Right? Particularly whenever a person is said under the Foreigners Act, the law is totally different. It has to be on the continuous document. And when you are saying that you have been staying in the rehabilitation camp at Tezpur since 1964, and you have been issued with such rehabilitation camp, where is it? None could place anything before the tribunal. And that is why this particular document was not exhibited.
Yes.
In the law, as you know, you have left that school in 1971. And you have obtained that certificate in 1993.
And it was required, but
22
earlier.
years,
Yes.
and that cannot be accepted as a valid piece of evidence. That's the law. That itself doubtful. The headmaster did not adduce any evidence,
He did not come.
and that okay. You pass the order.
All right, my lord.
You pass the order. Mr. S. Discuss. Mr. Das, you have been waiting since morning. How much time your item will take? It will take some time, or we can finish it off within half an hour. You could have mentioned in the morning. We feel sad. That was I asking my brother. We wanted to upgrade your matter since in morning you are sitting here. It's a fixed matter, right? We have it on 6th, the first item. After motion and this is in hearing. I think it is in hearing. So we'll take up the first item for hearing. Thursday. Okay? Recorded with whom?
Yes, yes.
Recorded with you.
And in this case, Lordship, A was supposed to argue, Lordship. He is also here. He is also here, Lordship.
Inform him, we'll have it on 6th. He's a whole person who has been. আর যেখানে এটি করো will rise for the day to day. Yes. এই ইয়ে করে দেন লিস্ট অন সিক্সথ is fine for hearing. Okay.
What? In your domain,
नहीं नहीं